Now let's start with chapter number 17. I have told you in the introduction of your part B that chapter 13 and chapter 17 are very important because both of them have huge weightage. So the weightage for chapter number 17 is approx 15 to 17 marks, just like your chapter 13. So if you want to score good in SBEC, it's compulsory to do these two chapters. Now, talking about your chapter number 17, we are going to learn various labor laws in that. Some of them I have introduced you in chapter number 13 itself when we did registration of ESIC, EPFO, right? So those are labor laws. But over here we are going to learn that in detail. Okay, not much detail, only that much which is relating to your startup. So SBEC is basically you're helping an entrepreneur to start a business. So how much ever is applicable to that entrepreneur, only that much provisions we are going to learn. Even I request all of you, don't do PhD in this, because in chapter number 17 itself we have 15 sub-chapters. How many chapters we have? 15 sub-chapters. So if you do PhD in each and every law or each and every sub-chapters, you would not be able to give attempt in June or December. Now, going ahead, chapter 17, as I told you, talks about the labor laws. So in this, we are going to learn 15 different labor laws about the gratuity, ESIC, Provident Fund, Industrial Dispute Act, we have Rights of Disabled Person Act, and many more. Please don't skip this chapter. It has a huge weightage and it helps you to clear your exam. Why? Because in this chapter you will get straightforward question. Basically part B you will get straightforward questions only. No case laws are given. Why? Because there is no scope of case laws. I hope you understood. So without wasting any time, let's start. So as I told you the name, compliances under labor laws. But entire compliance we are not going to learn, only that much which is applicable to set up a business, right? Weightage again I'll be writing 15 to 17 marks, okay? Now, the first law talks about Factories Act 1948. In chapter number 15, I have also introduced you with this law by reading what is a factory definition. So again we will revise that definition one more time. So which law are we starting now? We are starting with Factories Act 1948. So Factories Act 1948. Just we received our independence and then immediately law was made. Why? Because this law is a labor law. Which law is this? This law is a labor law. And as I told you earlier, the labor class was the most exploited class in the British era. So for protecting their health, their safety and welfare. What is the aim? For health, safety, welfare, we have various laws. So any person who is working in a factory, they will be entitled to get proper health, safety and a welfare. So health provisions are there, safety provisions are there, welfare provisions are there. Okay, which ministry is applicable over here? We had learned this. Ministry is your Ministry of Labour and Employment, MOLE. And who is nodal officer under this act? We have factory inspectors. These are not your police inspectors, okay? Area wise, district wise, there are factory inspectors. So this will be taking care about the compliances of the Factories Act 1948. Clear? Great. So in this Factories Act, what are we going to learn? 3 provisions. Health measures, as I told you, safety measures and the welfare measures. So before learning these measures, let's understand first what is a factory. What is a factory? Factory means any premises. Factory means any premises or presence. Any premises or presence where manufacturing process is going on. Which process is going on? Manufacturing process or its allied activities. Allied means connected activities like packaging, washing of raw materials, end products, etc. So any premises or presence where manufacturing process is going on or the allied activities are going on, and it is done by 10 or more workers working with aid of power. 10 or more workers working with aid of power, or 20 or more workers, 20 or more workers working without the aid of power. What is aid of power? Aid of power is nothing but the electricity. So 10 or more person working with electricity, 20 or more not using electricity but using their hands. So basically handicrafts. Okay. So any premises or presence where manufacturing process is going on or allied activities, 10 or more are working with the power, 20 or more without the aid of power, it will be called as a factory. Okay. But following are excluded from the factory. Mine is working underground for extracting coals, iron ore, manganese, petroleum. So mining is not included because we have different act for that called as Mines Act 1952. Along with that, the mobile unit of armed forces, even this is excluded. Whenever any war is going on, this armed forces, the soldiers, they make their small units wherein they also manufacture the weapons. So can you tell that as a factory? No, it is out of the scope. So mobile unit of armed forces will not be deemed to be a factory. Then railway running shed. Next one is railway running shed, again not a factory. Any of the eatery shops, hotels, restaurants, these all are excluded. These all are excluded. These are not factory. I hope this is very clear. This is definition of a factory. Please remember. So any of these premises which is a factory, it will be compulsory to do certain compliances. Now what are the compliances? We are going to see that. So what is the main aim of this Factories Act? The main object or aim is to provide adequate safety measures, promote health and welfare of the workers. So safety, health and welfare. It also includes other provisions like employment of children, women. All these are not in your syllabus. You have to just learn what are the health provisions, what are the safety provisions and what are the welfare provisions. Now we have already done with the definition of the factory, becomes very important to remember. Now next definition is a hazardous process. What is a hazardous process? When you are handling any of the dangerous chemicals or doing any of the hazardous process. Okay, very dangerous. How can you define dangerous? If you have not taken due care of yourself, this is going to hamper your health drastically. Understood? Getting only small pain, that is not hazardous, but which is going to affect your health drastically will be called as hazardous. So it is any process or activity in industry which is specified in the first schedule. Unless special care is taken, raw materials used therein or intermediate, finished product, byproduct, waste, effluent, any of these are hazardous in nature. This material is going to cause material impairment in health of any person. It may also result in pollution. So in that case, state government will give additional guidelines at how to handle the hazardous process. Okay. Now, who is a worker? Any person who is working in that premises in any capacity. Even watchman of this factory is also a worker under this act. Why? Because we have seen the definition, it covers the allied activity as well. Okay, so any person who is employed directly or by any contractor or agent with his knowledge or without knowledge of principal employer, he is working for remuneration or free, he is doing manufacturing process or cleaning any part, doing any other kind of work which is allied activity, that is incidental or connected to the manufacturing process. Okay, but the members of armed forces will not be covered. Members of armed forces means be it military, navy, air force, all these officers, these are soldiers of our union, that is our government. So they will not be covered under the workman definition. I hope this was very clear. Next comes, what is an occupier? Occupier means any person who has ultimate control over the factory. So this occupier's duty will be there to give this all health, welfare and safety provisions. That's why it's must to read the definition of what is an occupier. So occupier means in case of firm or any association of person, any individual or any partner can be deemed to be occupier. In case of a company, any of your director can be deemed to be an occupier. If factory is owned or controlled by a state or central government or local authority, they might have appointed any of the person to manage the affairs, right? But if they have not appointed, then government itself can be a occupier. I hope this is very, very clear. Now going to the next part, that is notice by occupier. Whenever occupier enters the factory or takes his position for the first time, before occupying the office of occupier in the factory, he should give intimation at least 15 days before to the chief inspector, that is chief factory inspector of that particular area, and this intimation will be in writing. And in that, what they have to write, what is the name and situation of the factory, then what is name, address of occupier, what is the nature of manufacturing activity, how many employers or workers are there. So this detail has to be given before 15 days of joining the factory. To whom? Chief inspector. So in case once occupier has taken position, after a few years he retires, so does he need to intimate that? The answer is yes. So when there is any change in the occupier, within 7 days of the change, we need to intimate to the inspector, that is the chief inspector, in writing. Clear with this? Understood about the notices? Now, what is the duty of occupier? It will be duty of occupier to give various health provisions, maintain welfare and safety in the organization. Now let's start with the health provisions. Yes, you can write with me or this notes will be there. You can take the screenshot of that, no problem. But it's very important, all this health provisions. So in health provision, the first one come as cleanliness. Please mind the spelling of cleanliness. Many of us write it as wrong. So what is cleanliness? Maintaining hygiene. So how to maintain hygiene? They have given us few pointers. Like factory should be kept clean. Okay. Factory must be kept clean. How factory can be kept clean? We have to do sweeping. Okay. We have to do sweeping and dusting. Entire factory. Sweeping and dusting entire factory every day we have to do. When we have to do? Every day we have to do sweeping and dusting of the factory. Are your employees going to do that? No, you have to appoint some other person for that. Okay, next. Whatever waste is there, proper provision should be there to dispose that waste. Okay, provision for disposal of waste. Okay, then your floors should be cleaned with the disinfectant. Floors in factories to be cleaned with disinfectants. This you need to do at least once in a week. Okay, at least once in a week we need to clean floors with the disinfectant. After that, we should maintain proper drainage system. So proper drainage system should be well constructed. In this, what was important to remember? Everything definitely, but sweeping, dusting every day, cleaning of the floors once in a week. Understood? Clear with this? Now going to the next one. Second. In health only we are going. First was cleanliness. Second was interiors and walls. Your interiors and walls should also be kept clean. How we keep our home clean, likewise we have to keep our factory also clean, because the workers are working there. Nobody will like to work in a dirty factory. Then once in every 14 months we have to do a whitewash or color in the interiors and walls. Okay, so whitewash or color, when we have to do? Once in 14 months. Okay, wherever possible we have to do varnishing. Varnish and repair your walls and windows. When you have to do? Once in 5 years. This timeline you need to remember, very important from your exam point of view. So whitewash color once in 14 months, varnish repair once in 5 years. Please remember. If your walls are washable, if your walls and interiors are washable, you have to wash it once in every 6 months. Wash once in every 6 months. Okay. Wherever we have smooth surface, okay, that should be cleaned once in every 14 months. Smooth surface has to be cleaned once in every 14 months. As far as your doors and windows are concerned, they need to be repaired or painted once in every 5 years. Okay, painted or varnished once in every 5 years. This timeline very important to remember. Okay, so this was your interiors and walls. Coming to the next, the third one. Third one talks about disposal of waste. Every factory should construct very good disposal system of waste, like we have for dry waste, wet waste, right? So we have to construct good system for disposal of waste. Okay. After that, fourth one is about ventilation and temperature. Ventilation and temperature becomes very important in our house also. If we close all the doors and windows, can we survive? No. Likewise, in the industry also, huge manufacturing units are there. So if that hot air is rotating around in the factory, there may be many diseases. So there has to be incoming going of fresh air. So the fourth one is ventilation and temperature. So in ventilation and temperature, we have to maintain adequate supply of fresh air. Okay. Adequate circulation of fresh air. This is essential. Also, we have to maintain adequate temperature. What is the meaning of maintaining adequate temperature? If any of the process is giving out very humid air, so you need to put air conditioners over there in order to balance the temperature. If any of the process is giving very cool air, the cool atmosphere is required, you need to put in any of the device like warmers for that. Okay, so you have to maintain the temperature, which is essential for every living being to survive. Okay, because living being cannot survive in too cool temperature and too hot temperature. The next one is dust and fumes. What is the difference between the two? Dust means the dust particles. Fumes means which is let out by your factories, that is your manufacturing unit. Those are fumes of your fire. Okay, so dust and fumes. Both of them are harmful for the human being. So employer should make arrangements that there is no inhalation of any dust or any fumes, because directly it get affected to the lungs of the human beings. Okay, so dust and fumes, there has to be adequate arrangement made to prevent inhalation by workers. So we should restrict that there is no inhalation of dust and fume by the workers. Understood? After that, we should always have an exhaust fan. Exhaust fan has to be fitted and running all the times. If your exhaust is not running, there is no use of that exhaust. Okay, exhaust is running at all the times. We should have internal combustion machine also. Internal combustion machine. Okay, this internal combustion machine is a machine which will be fitted along with the exhaust, and it will allow fresh air to come inside. Okay, exhaust to be connected with the internal combustion machine with the fresh air, so fresh air can come inside. Got it? Now the sixth one, we have artificial humidity. Now what is an artificial humidity? Certain industries like cotton openers, etc., they require artificial humid climate. Okay, so heaters are there to create those artificial humidity. Okay, if you keep your geyser on and bathroom door is closed, that humidity comes, right? So that is artificial humidity. Can we survive in that? The answer is no. So whenever any process requires artificial humidity, you should follow the guidelines given by state government and take all the measures so that none of the health of workers are affected. Okay, so What is artificial humidity? It artificially increases or decreases the temperature. Okay, so when anybody is doing that artificial increase or decrease, proper standards to be maintained. Proper standards to be maintained. Okay, then comes your 7th point. It is about overcrowding. What is overcrowding? In 1000 square foot factory, okay, say for example 5000 square foot factory, can you put 1000 employees to work? The answer is no. How will they work? There may be suffocation as well, there may be stamping as well. Hence proper work area should be given to every employee or worker. So overcrowding is not allowed. Okay, if overcrowding is done, workers cannot discharge their functions properly, right? Workers cannot discharge their functions properly. So what is the requirement? Every worker should get minimum of 1.2 cubic meter area. They should get minimum of 14.2 cubic meter workspace. 14.2 cubic meter workspace. This is compulsory. Please remember this. Okay. After that, next point, 8th one, we have a lighting. Proper lighting is also required, right? Can we work in the dark? No. Can you work in too much of light? No. And we have two types of light, correct? One is artificial light and another one is natural light. So we should have proper arrangement that both of the light are adequate. Okay. So suitable arrangement has to be made for lighting. Okay. Both of the lighting, that is natural and artificial. Suitable lighting arrangement should be made natural and artificial. Clear with this? Along with that, whenever we have glazed windows, these glasses are to be cleaned in and out. Because if your glasses are dirty, how are you going to get clean light? Correct? So glasses to be cleaned from both the sides. Okay, glasses to be cleaned from both the sides. Next comes your polished surface. Whenever we have a polished surface, high chances are there that when the sunlight or natural light reaches that polished surface, it may affect your eyes. Okay, so we should prevent the reflection. Reflection may create various problems. Suppose somebody is driving and if he has reflection, what will happen? May occur in accident, right? So in the same way, in factory there is manufacturing process going on and they are working in machineries. Any kind of distraction can lead to accidents. Okay, so we should prevent that. Apart from that, we should also prevent from shadow formation. Okay, we should not allow to form a shadow. What will happen because of that? There may be eye infection or there may be accidents as well. Clear? This was all about your lighting. Now the 9th point, drinking water. Okay, drinking water. Now it will be duty of every employer to provide with the wholesome drinking water to its employee. What is wholesome? Which is free from all the impurities. Okay, should provide wholesome drinking water. Okay, And this water should be available at the convenient places as well. Okay, what is the meaning of convenient place? Like suppose we have 4 floors in our factory and we have kept only one outlet of water, that is on the ground floor. Will all your workers come down and drink water? No. You should have at least one outlet in each floor. So it should be at convenient places, and as per the law, it should not be within 6 meters of urinals or spittoons. Okay, in malls generally we have, right, within 6 meters of spittoons, urinals or latrines. Drinking water facility should be away. It should not be within that 6 meters of urinals, latrines and spittoons. Also, we have to mention, okay, I hope you have seen, always they write drinking water, water for washing hands. You have to mention in the legible letters and in any language which your employees can understand that it is a drinking water. Clear with this? Understood? Now very important provision. When you have more than 250 workers in your factory, it will be compulsory to have a cooler. That means there should be arrangement for cooling water during the hot season, that is the summer season. Okay, so wherever more than 250 workers are employed, over there has to be compulsory facility of cool water. Okay, when in the hot season, that is a summer season. Clear with this? Understood? So this point becomes very, very important to remember. Now the next one, 10th one, we have latrines and urinals. Okay, every factory should have sufficient number of latrines and urinals. In your factory, if 500 workers are there, in that 500 only 10 urinals and latrines are there. Do you think it is sufficient? The answer is no. So every factory should have sufficient number of latrines and urinals, and during the working hours they should be available. It should not be locked. Okay, so it should be available at all working hours. Then male and female separate arrangement should be there. So separate arrangement should be there for male workers and female workers, right? In that latrine urinals, proper lighting should be there and proper ventilation should be there. It should be very, very clean also. Maintained, clean, and it should be sanitized regularly. Sanitization is must. You should keep one particular person for that cleaning and sanitization. Along with that, we should appoint a sweeper, as I told you. Is this clear? Everybody understood this, right? Latrines and urinals. Now the last one, this was your 10th. Now this is 11th one. Spittoons. Okay, many of the workers, they have habit to chew tobacco or pan, gutka, etc. And then they have to spit, correct? So they should not spit here and there. Proper instruction should be given. Hence for them, we should maintain proper spittoons at convenient places, and even it should be very clean and hygienic. Okay, spittoons should be there at convenient places, and it should be maintained clean and hygienic. Clear with this? Understood? So these are 11th health provisions which every employer or every occupier should give to its workers. Please remember, very important from your exam point of view. Now in the next video we shall start with the safety measures. Okay, in Factories Act only 3 things are important: health provisions, safety provisions and welfare provisions. So we have done with the health provisions. So now we are going to start with the safety measures. I hope you have revised your health provisions. Now we are going to the safety measures. These are little bit technical, okay, but if you revise it for 1 or 2 times it will be very easy. So first safety provision talks about fencing of machineries. Okay, fencing of machineries. So if you have seen any of the machinery, if you have not seen, then it's also okay. But if you have seen where the construction is going on or where the repairing work on the road is going on, they put some fence to that, because there is a pothole and nobody should fall in that or nobody should come to that place. So always there is a fencing, the border beyond which you cannot go. So whenever machineries are there which are very dangerous, which are operative, fencing has to be done so that there will be no accidents. Okay, so every dangerous part of your machinery to be properly fenced. Okay, every dangerous part has to be properly fenced. Because of that, what will happen? There will be lesser risk of the accidents. Second one talks about safety measures. Whenever any employee is doing work in motion, that is machinery which is in motion. Safety measures in case any employee is working near machinery in motion. Okay, so there is a machine which is automatically on and we have to always be safe, because if we come in contact with that machinery, that would lead to some accident or injury, right? So whenever any person is placed, that person has to wear fitted tight clothes so that none of the organ or cloth come in contact with that machinery. Okay, so all parts of your machinery, that is which is moving on its own, it should be properly lubricated. Lubrication happens with the oil. Okay, if they are properly lubricated, there are less chances of accidents because they will work very smoothly. Then in this machinery only male members are allowed to work. Females and children are not allowed to work. So on this machinery only male members, that too male adult members, and this adult member should also have a certificate having fitness certificate. This fitness certificate is given by the certified agent. Okay, that is your doctor. So only these people can work. And when they are working on this machinery, it will be important to wear fitted and tight clothes. Wear fitted and tight clothes. So this was about the machinery which is in motion. Now the third one, we have employment. Can we employ youngsters? Or youngsters means not your adults, but who are not child but they are adolescent between 14 to 18. Can they employed in the dangerous machinery? The answer is no. So there is prohibition of employment of young person. Now this young person, remember, it includes these two categories. Okay, child is totally prohibited, he cannot. And adolescent may work. So adolescent, I can say it is restricted. So adolescent may work on the machinery provided these conditions are fulfilled. So there are exceptions to this rule. What does it say? If sufficient training is given to that adolescent person. Okay. In case sufficient training given. Okay. And under adequate supervision. Sufficient training given and adequate supervision. Only then adolescent can work. For children, it is prohibited. Clear? What is adolescent? Within 14 to 18 years. Completed 14 but not completed 18. Okay. After that, going to the fourth one, self-acting machinery. Self-acting machineries are very dangerous because they operate on their own. So when they operate on their own, high chances of accidents are there. Okay, so on this self-acting machinery, you cannot be beyond 45 centimeters. If you have seen any of the rides in the amusement park, that ride moves, right? Okay, on its own, and there is a well boundary. We cannot cross that, otherwise there may be accident. But that machinery, till what it can operate, it cannot cross a 45 degrees or 45 centimeters from its stillness. Okay, so where it is standing, from that it can operate this side 45 and this side 45, not beyond that. Please remember. Okay, also proper fencing system should be there. Okay, and for switching off this self-acting machinery, there has to be one switch in each floor. So in case of accident, to reduce the damage of that, we can switch it off immediately. Okay, so there has to be proper switch off system, and it should be well accessible at all the times. Okay, this will reduce your damage which will happen in your accidents. Going ahead, the fifth one, casing of new machinery. Casing of new machinery. Whenever any new machinery has come, you have to install it. You have to make sure you are fixing all the nuts, bolts, screws, everything properly. Because if any of the part is not fit properly, it will be a huge accident. So once it is installed, experts or other people who are seniors, they have to use that machinery. After that, they should give supervision when the newcomers or young workers are working on it. Okay, only after using that machinery for several months, it can be handed over for their own. Clear with this? So new machinery, there has to be proper fitting of nuts and bolts. Proper checking should be done of that, and it should be operated under supervision of expert or senior. Clear with this? This was your fifth point. Now, there is certain prohibitions. Women and children cannot be employed in the cotton opener industry. Cotton opener industries are very dangerous, and hence women and children cannot be employed. So, there is prohibition for, please remember, women and children to work in cotton openers. It is one kind of an industry. Okay, yes, only this much you have to remember for the cotton openers. Now going to the next point, it's hoist and lifts. Hoist and lifts. What is a hoist and what is a lift? Lift everybody knows. Okay, there is one closed cabin and people and goods are taken from one floor to another floor. That is a lift. What is a hoist? It's a crane like material. Okay, huge one it is. It's open and goods are taken from one floor to another floor. So that is hoist and lift. So hoist is only for goods. Lifts is for goods and people, both of them. Okay, so hoist and lift should be of very good construction and good strength also. Okay, so it should be very good construction and at the same time good strength. Definitely it should be checked by competent person before using that, and you have to do servicing of that. Okay, so servicing checked by competent person, that is servicing to be done once in every 6 months. Once in every 6 months. Please remember this. This is a short notes I'm writing for you so that it becomes very easy for you to learn. After that, your lifts should be enclosed with the proper fitted gates. Okay, your gate should be properly fitted and it should open only on the floor. It cannot open in between. Okay, then also you have to write what is the maximum load allowed. Okay, this should be mentioned very clearly in the hoist and lift, and the people should also obey that. Otherwise, when in lift we write 6 people allowed, automatically 8 people come there. So we have to take care of the maximum weight because it is going to reduce the life if you don't obey the instructions properly. After that, maximum load is done. Now door should open. We discussed this on landing or when it is stopped. Okay, so these were the provisions for your hoist and lift. Please remember this. Going ahead to the 8th one, we have lifting machines and chains just like your crane. Okay, you might have seen in the construction sites, right? There is lifting machines, heavy stones and all are lifted. Even trucks are lifted. So lifting machines and cranes. When there is guidelines for this lifting machines and cranes, there has to be fixed to a particular rope. It has to be movable and well lubricated. This has to be movable and well lubricated so that it functions very nicely. Then the chief inspector should come and check it once in every 12 months. Chief inspector should come and check it once in every 12 months. For hoist and lift it was 6 months. For lifting machine it is 12 months. Please remember this. The next one, we have floors and staircases. Whenever we have lift also, then also we have floors and stairs. Why? For emergency. So your floors and staircases has to be always accessible. You cannot block it with any other goods or material. So it should be always accessible. It should be a very good and sound construction. And it should be of one type only. One step is big, another is small. This does not work. It has to be of sound construction. Then it has to be kept clean all the times and free of all the hurdles. No hurdles should be placed. Can you keep your materials, machineries on the floors? No. who cannot keep. Okay. After that, the 10th one, we have pits, pumps and openings. Pits, pumps and openings. Wherever you have pits, pumps, openings, proper fencing should be there in order to avoid the accidents. Okay, you should always mark that area with a bright light so that nobody goes there, and if anybody goes there, you should understand and that person should understand. Okay, so pits and pumps should be properly covered and properly fenced also. Okay, then the next one we have excessive weight. Can you force anyone to carry excessive weight? The answer is no. If person is of 40 kg, you tell him to carry 60 kg, he will die. So you are prohibited. Employer cannot force anybody to lift the excessive weight. Okay. Not let workers to carry load which can cause injury to body. Injury to their body. Okay. After that, the 12th one, we should also protect our workers from dangerous fumes and gases. So protection from dangerous fumes and gases. See, these workers, sometimes they have to work inside the ground, under the ground. So under the ground, so many gases and fumes are present. We don't know that. So we should protect them and make suitable arrangement that before that worker goes in to work, that gas or fumes are removed from there. So after removal, one person can go. Plus, underground there will be no light. So we have to carry those batteries and bulbs and all. So those battery bulb should be of such material. If it comes in reaction to any gases, it should not be explosive in nature. I hope you understood. So these are the arrangements required for protection against dangerous fumes and gases. So the first one, people working in pits or pumps, pits or openings should not be allowed to go, okay, unless dangerous fumes and gases are removed. Okay. Okay. So dangerous fumes and gases are removed. So once these gases are removed, a certifying authority should give a certificate that there is no presence of gases and fumes, then only workers can enter. So competent person shall give certificate. With certificate, there is absence of any gases. Now it is safe for employees to go and work there. Is it clear? Great. Then your pits and pumps, if you want to carry only portable light, only portable electric light. You cannot carry anything of any radius or anything like that, because that is very, very explosive. Now the next point is the 13th. Only few more guys and we are done. Precautions in case of fire. Okay. It will be duty of every occupier to give proper training in case of emergency. So when there is a fire, proper training has to be given to workers how to use the fire extinguishers. If there are fire extinguishers but training is not given, what's the use of that? Okay, so proper training is required. Also, proper facility should be there, like fire extinguishers and water supply and all, to control the fire. Okay, so first of all, give training the workers or employees to deal with the fire extinguishers, and there has to be fire extinguishers fitted well in the industry. The last one, 14th one, there is compulsion of a safety officer. Okay, safety officers should be there where 1000 or more workers are there. So it will be duty of the occupier to appoint safety officer inside your factory itself. Okay, in factory, if number one, 1000 or more employees are employed, or your manufacturing process, or you are handling the hazardous chemicals. Okay, second one is you are manufacturing or you are handling hazardous chemicals. Clear with this? Understood? So safety officers will be compulsory where 1000 or more employees are there, or where you're carrying out any of the hazardous process or handling the hazardous chemical. So this where your safety measures, guys. I know little bit it was lengthy, but please remember, if it is asked in exam, you have to write at least 7 or 8. Okay, now we are going to see various welfare provisions. I hope you have understood what are safety provisions and the health provisions. Now we shall proceed with the various welfare provisions. So in the welfare measures, the very first one is providing with the washing facility. Washing facility, I mean the washing of clothes facility, because the workers are working in the manufacturing process, so their clothes might get dirty, and basically their residence is inside the factory only, that means in the nearby premises. So when they are working in the factory, whenever there is a night stay in the factory, there has to be a facility to wash their clothes. So adequate and suitable washing facility which can be used by the workers. Apart from that, whenever they wash their clothes, obviously we need to dry them. So there has to be the drying facility as well. And workers carry 2 sets of clothes, that is their own clothes and the one which they have to wear while they are in factory. So basically it's a uniform. So when they come to the factory, they are in their own clothes and then they change in the factory. So when they are changing and wearing the uniform, there has to be a place where they can use to keep those unworn clothes. Okay, so their home clothes they can store somewhere. For that, suitable storing facility has to be there, just like the locker. Okay. After that, in various manufacturing process, it is compulsory to stand. So workers have to stand for a long time, and it's not good for the health. Hence, whenever they take a break of 2 minutes, 5 minutes, a suitable sitting arrangement should be provided nearby, where they can go and sit for a while and again resume with their work. Then first aid appliances are to be provided. First aid is very, very important. Accidents do happen in the factory. So till the time they are reached hospital, more damage should not happen. That's why first aid is essential. So provision of first aid says that there has to be a first aid box, one first aid box in every 150 workers. Okay, so every 150 workers, one box. If there are 200 workers, then 2 first aid boxes will require. And having that box is not enough, but having the essential requirement in that box is important. So there is a list that what all items are there to be in the first aid box. So that list has to be taken care of, and all the items should be there during all the working hours, and it should be accessible. Where in a factory 500 or more, that is more than 500 workers are there, for them it will be compulsory to have an ambulance room. Okay, so in more than 500 workers are employed, ambulance room becomes compulsory. After that, canteen facilities. Providing of canteen facility is important and compulsory where more than 250 workers are there. Guys, you have to remember this number. Always remember. What will happen where 500 or more are there, 250 or more are there, because this is only asked in the exam. Okay, so where more than 250 workers are there, it is compulsory to have a canteen. Eating place is always there in the factory, but apart from the eating place, canteen where food is sold, so it will be compulsory to have canteens. Apart from that, restroom, shelters and lunch rooms will be compulsory. So where more than 150 workers are employed, restrooms are compulsory where they have to do night duty, they can rest. Shelters are necessary where they can leave, and lunch rooms are necessary where they can eat their food. Also, good wholesome drinking water facility should be provided so that it is accessible to them. Crutches are compulsory where more than 30 women are working. So where more than 30 women are working, crutches facility is compulsory. Crutches facility is for children under age of 6. So there a nurse will be there who will be taking care of the children. Then it will be compulsory where 500 or more workers are employed to employ welfare officers. Safety officers were compulsory in 1000 or more officers, and welfare officers are compulsory in 500 or more employees. It will be compulsory for employer to employ welfare officers. I hope you have understood this. So this is all with your welfare measures. So we have seen health, safety and measures, that is welfare measures. So with this we complete our Factories Act. Only this much syllabus is there for you, and it will be duty of all the employer when they are in factory to provide with all this to their employees. Now let's start with our second chapter under this chapter number 17. So name of this act is Employee State Insurance Compensation Act 1948. Okay, so I have introduced this to you in chapter number 13 also, right? We had seen how to take the ESI registration. So ESI registration is taken by whom? That we have seen. Eligibility we have seen, and what is the benefit of that we have seen. So in this chapter we are going to learn little in detail. Apart from that, you know what is a benefit. So to sum up, Employee State Insurance Corporation aims to give the health benefit or the medical benefit. Okay, in the health benefit, what it needs to tend to give? Medical benefit. This medical benefit is given to the worker, along with that his family members as well. So worker and family members, both of them are included into this benefit. So what is the aim of this act? First we will go to that. So this legislation is for the social security of the employees in India. Okay, it is for the protection of employees in case of contingencies. Contingency means emergency situation like illness. We have long-term illness or sickness like cancer, leprosy and all, right? So whenever employees are going through this illness, they won't be able to come to the company or a factory, so they will be losing their remuneration. Along with that, they have to pay their bills, that is hospital bills, dispensary bills. So it is a burden on them. This affects the workers drastically because they don't have more of the savings as the salary is very less. So in order to help them, okay, the insurance is taken. and in case any employee is sick, that employee or the family member shall get free of charge treatment in any of the ESI recognized hospitals dispensaries. Also, he shall get half of the income what he is earning, even though when he is not coming to the factory to work. These are the benefits provided to support them in the difficulties. Okay, so whenever he is ill or sick, the protection is given under ESIC. So for covering the illness, long-term sickness or any other risk due to employment injury or any other injury, ESI is there. Okay, so medical benefits are also given to legal dependents of the employees. Even this is extended to the retired person. So even though your employee is retired, still ESI will be extended to him. Object we have to remember, because they ask in the exam, what is the object? To give benefit to the employees when they are sick, maternity, employment injury or any certain matters. Okay, this is the object of this act. Now coming to the definitions, where it is applicable to all the factories and all the shops and establishment. So ESI is extended to all the factories, shops and establishment. Whenever your appropriate government thinks that the ESI has to be there in particular industry, it shall give publication in the official gazette, and after 1 month of that it shall be applicable to that particular industry. Once ESI is introduced, it will continue irrespective of number of employees going down. Like for example, what is the eligibility for ESI? Whenever in any factory 10 or more workers are employed, ESI is compulsory, right? So once ESI is compulsory, it has to be continued irrespective of number of employees going below 10 also. So once applicable, always applicable. Please remember this. Going ahead, who all are covered under this act? Under this act, all non-seasonal factories, all the shops, all the establishment where 10 or more people are working. How many? 10 or more workers are working. This will be applicable. So every employer who has 10 or more workers working, it will be compulsory to take ESI registration. How to take ESI registration we have already seen. Yes. Okay. And now when any factory or any shop or establishment, it is covered under this act. So do you think all the employees shall be covered? The answer is no. Only and only eligible employees are covered. So who are eligible employees under this act? Any employee who is earning wages of 21,000 or less. So wages not exceeding 21,000 employees shall be included. And in case of a disabled employees, little subsidy is given to them. So employees with less than 25,000 salary will be covered under the ESI. So 10 or more is a limit for employer. 21,000, 25,000 will be the eligible employees under the ESI. Very clear with this? Great. Now, as I told you, ESI is extended to various shops and establishment also. So, let's read the definition where it is covered. All the shops, all the commercial establishment, everywhere ESI shall be applicable. So, in addition to the factories, ESI is applicable in all shops and establishment. Also, it is applicable in cinemas and previewing theaters. Also, in all the hotels and the restaurants, all the clubs, the newspaper establishment and your road transport establishment. So, ESI is applicable in all these enterprises. Please remember it very carefully. Now going ahead, appropriate government may exempt various public sector undertakings from this. Okay, it may exempt various PSUs. Why? It will exempt PSUs because PSUs are offering similar kind of benefit. What are they offering? Similar kind of benefit they are offering to their employees. So can anybody get double benefit? The answer is no. Double benefit is not possible. Hence, appropriate government may exempt PSUs from giving this ESI. Very clear with this? Understood? Now, coming to our notes. As I told you earlier that every month, okay, every month, two parties have to contribute for ESIC. So one is your employer who will be contributing. Another one is an employee who shall be contributing. So employer and employee shall be contributing out of what? Employer and employee shall be contributing on the basis of worker's wages. Worker is your employee. Yeah? Don't get confused. Worker, employee, one and the same. So on the basis of worker's wages, your employer and worker will be contributing. So where are they going to contribute? In one fund called as ESIC. Okay. So how much employer is going to contribute? Employer is going to contribute 3.25% of wages of employee or worker. Okay. How much? 3.25% of wages of worker. And how much employee is going to contribute? It is going to contribute 0.75% of its wages. Okay. So suppose employee is earning 10,000 per month. So employer shall be giving 3.25% from his pocket and employee shall be giving 0.75%. Now how are they going to contribute? It will be duty of employer to deduct ESI from employee's salary. Okay. So whatever wages he is paying, from that wages he shall be deducting and putting amount in this ESIC fund. I hope this is very clear to all of you. Okay, so this is a contribution by both of them. Employer has to contribute 3.25% from his pocket and 0.75 he will be deducting from the wages of the employee. Now what are the benefits given? Benefits we have discussed in chapter number 13. One more time I will be telling you. Benefit under ESIC. In this ESIC fund, okay, ESIC fund is maintained by your central government. So central government has established various ESIC hospitals, ESIC dispensaries, ESIC intensive care unit, etc. Okay. So whenever any of the employee or his family member, he is sick, not well, he can get services from this ESI certified hospitals, dispensaries, ICUs, etc. Also they have hospitals for cancer and hardcore diseases. So they will get treatment almost free of charge. Like if we are hospitalized, our insurance companies pay for our bill. The same concept. Employees are paying the premiums in the form of contribution to ESI, that is 3.25 and 0.75. And once they are ill or sick and they are hospitalized, getting some treatment, they can claim free of charge services from any of the ESI certified hospital, dispensaries, ICUs, etc. But yes, that has to be ESI certified. And your government has established various hospitals and dispensaries across India to help these workers. I hope this is very clear to all of you. Okay. Now, along with this benefit, free of charge treatment, they also get something called as periodical payments. So even if they don't go for work, still they will get some salary, not the entire salary, but some salary in their account. Okay, so this is also one of the benefit under the ESIC. Registrations and all, these are not there in your syllabus. Now, coming to the contribution, as we have written, how much employer has to contribute? 3.25%, employee has to contribute 0.75%. But it is whose responsibility to contribute? It is responsibility of a principal employer to do the contribution. So it will be responsibility of an employer to do the contribution. This contribution, it is deposited in a common pool called as ESIC fund. And how this fund will be utilized? To pay the cash benefits to the insured person, along with that to the family members, also give them medical facilities to them, and also to the beneficiaries. Okay, now as I told you that it will be responsibility of an employer to give or to pay the contribution to ESIC. Suppose we have a contract labor. Contract labor means who is not directly appointed by the principal employer, but he comes from a contractor. So contractor pays them salary, right? So in that case, how principal employer is going to deduct? Understood? So when any of the employee is appointed through a contractor, it will be duty of a contractor. Okay, it will be duty of a contractor to deduct from his salary and pay the contribution. In case of default, it will be the prime responsibility of principal employer only to deduct and pay to the ESIC, and principal employer then can recover that from the contractor from his commission. This was very, very important. I hope you have understood this chapter very nicely. This is all with the ESIC. Now let's start with the next act, that is Employees Provident Fund Miscellaneous Provisions Act 1952. Now again, this is a labor law. We are studying labor laws only, but the basic aim is little different. This act provides for the retirement benefit. What does it provide for? It provides for the retirement benefit. Okay, so this act, the earlier act, that is ESIC, it was dealing in the insurance. So when any employee is sick, okay, in that case that medical benefits and all will be given. But this provident fund is like your retirement benefit. All the workers work during their age, young age, and after 60, 65, 70 years, depending upon the type of occupation you are doing, we have to retire. So once we retire, after that salary won't be coming. So how are we going to earn our living in that case? So in that case, this provident fund shall act as a real hero for us. So right from the beginning, when then worker starts earning, some part of his salary is deposited to a fund called as Employees Provident Fund. Okay, and in that fund it will be a saving. So he will get interest on that, returns on that, and once he is retired, he will get that amount, and then the retirement can be earned because of that amount. I hope this is very, very clear. So Employees Provident Fund Miscellaneous Act, basically it's a social welfare legislation which provides for provident fund, pension fund and a deposit linked insurance fund. But in your syllabus you have only provident fund, hence we are not going to learn the pension fund and the deposit linked insurance. So all the employees who are working in particular establishment, it will be compulsory to give contribution to the provident fund, and then they can enjoy in their retirement. So the act aims to give social security and timely monetary assistance. So whenever their family require money at that point of time, they will be giving, that is your provident fund shall be giving the relief. So in this particular act, miscellaneous provisions, that's why the name is, 3 schemes are there. One is provident fund scheme, another one is a pension scheme, and the third one is deposit linked scheme. But in your syllabus we only have a provident fund scheme. Okay, so we are going to learn only that much. Going to the applicability, where it is applicable. All the establishment, every establishment which is factory, which is not a factory, which is specified, which is engaged in schedule 1. Okay, any industry which is given in schedule 1 and where 20 or more people are working. So any industry which is given in schedule 1 and there 20 or more persons are employed, to them the provident fund becomes compulsory. Okay, in any other establishment, if less than 20 are there or 20 or more are there, if central government thinks that over here it should be applicable, by giving in the official gazette, it can make that industry also included in the list. Now, where any establishment where less than 20 workers are there, but that establishment wants that provident fund benefit to be given to its employees, so they can make application to the central government, and once central government notifies them, that means it is agreed to give them benefit, at least 2 months notice will be given by central government and then act becomes applicable. Okay, yes, so once provident fund is applicable, it is always applicable. So again the same rule, once applicable, always applicable. Okay, once applicable, always applicable. So on this you have many case laws in your exams, that in so and so in a year the establishment had 21 employees and in 2020 they reduced the number of employees to 17. So is act applicable? You have to say yes, act is applicable. So once act becomes applicable to any industry, irrespective of number of employees, then they are increased, they are decreased, the act will continue to apply. Okay, now this act is not applicable to certain establishment. Which establishment? Cooperative Societies Act, okay, or State Cooperative Societies Act, where less than 50% are employed without the aid of power. So it is not applicable to cooperative societies and state cooperative society where less than 50 employees are there working without the aid of power. Also, it is not applicable to any establishment which is in control of central government or state government where they are getting the similar kind of other benefit. So when similar kind of other benefit is given, the double benefit will not be given to them. Okay. Yes. After that, going to the important definitions. What is an appropriate government? Any establishment which is under control of the central government or which is connected to railways, major port, mine, oil field, controlled industry, or which has branches in more than one state. For all of this industries or enterprises, your central government will be appropriate government. And apart from above, for all others, it will be their respective state government. So if any industry is located in Maharashtra and it is not of any of the character of this, it will be a state of Maharashtra government shall be the appropriate government for them. Now, who is an employee? Employee's definition is same like your Factories Act definition, so we need not read that. So what is this EPFO scheme? There is a Employees Provident Fund scheme, okay, wherein the fund will be there and fund will be managed by your central board. Central board is constituted by your central government. Okay, yes. Under this EPFO scheme, Employees Provident Fund scheme, both of the parties have to contribute. Employer has to contribute and employee has to contribute, same like your ESIC. Over here we have equal contribution. How much they are going to contribute? Equal contribution both of them are doing. In some cases 10%, in some cases 12%. The general rule is 12%, but in certain cases 10%. So 12% of what? It will be the wages of the workers. So 12% of basic plus DA plus your retaining allowance. Basic plus DA plus retaining allowance. Clear? So all the employees are covered, be it employed by your contractor, so directly appointed or indirectly appointment, all of them are covered. So how much they have to contribute? Employer 12%, employee 12%. Okay. Now in which cases 10% is there? Okay. In which cases 10% they have to contribute? Where less than 20 employees are there. In case of sick industries or any of the industry which is going for reconstruction with the IBC, that is Insolvency and Bankruptcy Code, this will be learning in the part C. Or any industry which has negative net worth, heavy losses, and any industry dealing in jute, BD, brick, coir and a gum factories. For all this 10%, apart from this 12%. Okay. Now suppose if any of the employee want to save more, okay, they want to contribute 15%. Can they do it? Why not? It is his salary, how much ever he wants he can. But can he force the employer also to give this much? No. Employer shall be paying only and only 12%, and it is employee's wish, it can opt to contribute more also. Clear with this? Okay. Now, which all employees are covered under this? Are all eligible employees? No. Eligible employees are who are earning salary up to 15,000 rupees. So any employee who is earning more than 15,000, there will be no obligation for an employer to contribute. Very clear with this? Understood? Please remember this. Okay. Now it will be whose responsibility to contribute? It is a sole responsibility of employer to contribute. Okay. Same. Okay, so he will be deducting from the wages of the employee and contributing the same. So this is all with your employees provident fund. Okay, yes, only the limits you have to remember, applicability you have to remember, that's it. Registration we have already done in the chapter number 13, because in chapter 17 you don't have the registration part. Now let's start with the next chapter, that is Payment of Gratuity Act 1972. It becomes very important to remember the year also. Like we cannot spell our name without our surname, in the same way year becomes very important for you to remember. Now what is a gratuity? Okay, gratuity is nothing but a thank you. Okay, gratuity is nothing but thank you. Now who says thank you? Thank you is said by employer to employee. Okay, thank you is said by employer to employee. Now why will any employer say thank you? Employer shall say thank you because employee has given so many years to his organization. Even though employee was getting salary, but whenever your employee retires, it will be responsibility of employer to say thank you and give a token of appreciation to that. So this token of appreciation is nothing but the gratuity. So unlike your ESIC and Provident Fund, in this gratuity, neither employer nor employee contributes for this. But this is a lump sum amount. What is this? A lump sum amount paid by employer to employee whenever employee retires. Okay. So whenever employee retires, employer pays a lump sum amount to the employee. I hope this is very, very clear. Yes. So even this is a right of an employee and it becomes compulsory to give the gratuity in the event of resignation or retirement of your employee. So what is a gratuity? Latin word for this is gratuitous. Gratuitous means when someone has done something for you, you should show gratuitousness towards them. So showing gratitude is a sign of giving a gratuity. So gratuity is in the monetary terms. Okay. So gratuity is payment made by employer to employee at the time of termination of his service, first of all, by retirement or superannuation. What is superannuation? It is another kind of retirement. Mostly superannuation happens at the age of 58 years. So any employee is terminating his employment by resignation or superannuation or retirement or resignation, termination of his service. Okay. So that is a gratuity. If that person dies, in that case, will he get the gratuity? No, he will not get the gratuity. Very clear with this? Understood? Now, it is also a retiral social security benefit. This you will get when you leave the organization, not necessary you will get it after the retirement. Okay. If you have worked for certain number of years, which is required in the Gratuity Act, you can get at age of 40, 35 when you are leaving that organization. It is not necessary like your Provident Fund to get the amount after retirement. You can get it any point of time. So what is the gratuity? It's a lump sum amount paid in consideration of past services. Okay. So gratuity is nothing but a relief to a retired person and also to its family members. Very clear with this? As I told you earlier that whenever any person dies, okay, indirectly he is retiring. So when he is retiring, will he get the gratuity? The answer yes, he will get the gratuity. And this is a statutory right. So when any employer do not pay gratuity, can employee go to the court of law? Yes, employee can go to the court of law when his right is not there, because payment of gratuity becomes a statutory right. Please remember. So let's go to the important definition. What is the appropriate government in this? Appropriate government means any organization which is in control of central government or which is having more than one branch in more than one state, or any factory which is under central government, or port, mine, railways, oil field. For them the appropriate government is central government, and for all other cases the appropriate government is your state government. Now what is an employee? Employee means any person who is not an apprentice. Remember, apprentice means training. Okay, trainee will not get the gratuity. So any person other than apprentice, any person other than apprentice who is working for the wages, doing any kind of work, manual, skilled, unskilled, super skilled, who is working anywhere, factory, mine, oil field, plantation, port, railways, okay, all this will be covered. But certain person who is holding post under central government or state government or any other rules they will not get gratuity. Why? Because they are having similar kind of other benefit. What they are having? Similar kind of other benefit. So when they are having similar kind of other benefit, they will not get the double benefit. Okay. Now going to the definition of employer. Who is an employer? Listen to this very carefully. This will help you in the other chapters as well. When any establishment, it is under control of central government, okay, which is under control of central government appoints a supervisor or manager for that. So in this case, your employer is a supervisor, okay. Same is for the state government as well. When any organization is under the state government, they will also be employing the supervisor or manager to look after the affairs of that organization. So that supervisor or manager shall be the employer. In case of default means your central government did not appoint the supervisor or manager. In that case, who is the employer? The head of that particular department, central government department or the state government department. Understood? He is an employer. When we talk about local authority, when any organization is under the local authority, in that case they will also be appointing any supervisor or manager. Yes, so he will be employer. If not appointed, in case of a default, okay, then the chief executive officer of that department shall be the employer. So please remember this definition, okay. When we talk about the private institutions or the private organizations, okay, in case of a private organizations, any person who is having ultimate control over the affairs, that person will be the employer. He can be named in any capacity: manager, director, promoter, proprietor, any capacity. Got it? Clear with this? So please remember, this will help you in your other chapters as well, because similar kind of definitions you will find. What is a superannuation? There is an age in every company or enterprise to retire, so that is a superannuation. Now, where is this Gratuity Act applicable? Gratuity Act is applicable in all the factory, mine, oilfield, plantation, port, railway company. Where 10 or more workers are employed, Gratuity Act becomes applicable. Okay. It also applies to shops establishment. All the shops establishment where 10 or more people are working in the preceding 12 months. It also extends to other establishment where 10 or more employees are working in preceding 12 months. So which all establishment? They have included club, motor transport undertaking, local bodies, chamber of commerce industry, circus industry, inland water transport, and the solicitor office, that is your lawyer's office. So all these are covered under the Gratuity Act, please remember. Now, for eligible, that means employer has to be eligible for gratuity. Now employee has to be eligible for the gratuity. Now in which circumstances we can call that employee is eligible? Employee is eligible to get gratuity when he has given 5 years of continuous service. What he has done? 5 years of continuous service in organization. So he has worked for at least 5 continuous years. Now what is the definition of a continuous service? This is a definition of continuous service. So when he has taken leave for any of this reason, he will be deemed to be in continuous service. That is your sickness, when he is sick, accident, absence from duty without leave, Layoff. What is a layoff? Layoff means when any employer is not able to give work to its employee because of shortage of coal, shutdown or breakdown of industry or any other reason, but there is no fault of employee. Okay. Then strike. Strike is done by an employee when demands are not met. Lockouts are done by the employers when employees don't listen to him after giving various warnings. And cessation of work has happened, but it is not fault of employee. So in this period, even though his service is interrupted, but still he will be deemed to be in the continuous service and he will be eligible for the gratuity. So in short, he should work for 5 years so for getting the gratuity. Remember one thing, guys, this 5 years, okay, this 5 years requirement will not be applicable in two cases. Okay, where first in case of a death and second there is some permanent disability. Okay, we will come to that point, don't worry. Now going to the payment of gratuity. When is your payment of gratuity done? Payment of gratuity happens on termination of contract. You have contributed 5 years continuous service, then you will get your gratuity. So on superannuation, on retirement, on resignation, or death or disablement due to accident or disease. Okay, in 4 cases you will get your gratuity if you have given continuous service. So as I told you, 5 years of continuous service will be required, but it will not be required in 2 circumstances. Which circumstances? In case of death or disablement. So in case of death or disablement, if you have given only 3 years of service, 2 years of service, then also you will be eligible for the gratuity. Okay, and in case of death, gratuity will be given to whom? First to the nominee. If there is no nominee, then the legal heirs. It will be duty of every employee to fill the nomination form. Nomination is compulsory. So in case of a death, who will get the gratuity? So that is a nominee will get gratuity. Okay. Can your gratuity be forfeited? Yes, maybe. Basically, gratuity is a statutory right. So employer should strive to give gratuity, but in certain cases when there is a fault of employee, he may forfeit the gratuity. So when he may forfeit the gratuity? When his services are terminated because of some act which was willful omission or negligence. Okay, it was willful omission or negligence which has resulted in damage or destruction to the property of the organization. Okay, so whatever is a loss occurred to the employer, that much part employer can deduct from his gratuity. Okay, so extent to the damage or loss, it can be deducted. In some cases, employer may forfeit whole or part of gratuity. Now, in which cases? If the services of employee was terminated because of some act which was riot, he induces people to fight, that is riot, or disorderly conduct. He does violent acts in the organization. So his full or half gratuity may be forfeited. Or his services are terminated because he has done an offense which involves moral turpitude, or this offense was committed when he is in course of his employment. If he has done moral turpitude outside the factory, there is no connection, that will not be forfeiting as gratuity. So he should do the act of moral turpitude when he is in employment. In employment does not mean he is in factory, but if he is going out for work of any factory, there also he should behave properly. So if he conducts any of the offense there also, then also it will be deemed to be in the employment. Clear with this? So I hope you have understood the Gratuity Act. That's all for this act. Yes, Employees Compensation Act 1923. Now, what is the objective of this act? This is similar to ESIC. So remember one thing, wherever any employee has ESIC benefit, whenever any employee has ESIC benefit, they will not get benefit under this act. So in ESIC also medical benefits are given. In employee compensation also medical benefits are given. Hence when employee is getting ESI benefit, they will not be getting employee compensation. I hope this was very clear. Now, what is the employee compensation? When any employee is working in an organization and while he is working, he meets with some accident or any sickness or any disease, okay, he is sick, he is not okay as far as his health is concerned, or he has some occupational disease because of the employment where he is working. So accidents are very common. What is occupational disease? Occupational disease means, say for example, any person is working in chemical industry, so he is having cancer. So that is the occupational disease which happens because of the employment. Okay. So in that case, whenever disease occur because of the employment, he shall get the compensation under employee compensation. And it will be whose responsibility? It will be the employer's responsibility to give that compensation. Again, if that employee is getting the ESIC benefit, he shall not get compensation under this act. So please underline the object of this act: to provide assistance to employee when he is injured or during the course of employment and out of the employment. And what is the intention of this act? It is not to punish the employer but to help the employee. So whenever any employee suffers any injury, he should not go to any court of law, but he should always file application under this act. Very clear with this? Understood? This act is very short in your syllabus, so we are not going to learn any definitions or anything. Directly we shall be going to the how much benefit they can be given. Now, how much amount of compensation can be given? Okay. This amount of compensation is he will get when he is injured or occupational disease. So when death occurs, in that case, the formula is 50% of monthly wages into relevant factor. Now what is relevant factor? There is a schedule, that is a table given under this act wherein the age is written. So how much ever aged you are, you will get that much. So 50% of monthly wages into relevant factor, or 1,20,000 rupees, whichever is higher. Okay, so in case of death, you will get any of this, whichever is higher. In case of total permanent disablement, you will get 60% of monthly wages into relevant factor, or 1,40,000, whichever is higher. In case of partial permanent disablement or total disablement, the formula is same, only you have to add loss of earning capacity. How much you have lost your earning capacity, as per that you will get the compensation. And when you have a temporary disablement, even though you are not going to work, still half monthly wages will be given to you till 5 years or till the time you get well. Okay, so these are the amount of compensation given. Now, under this act, it will be responsibility of an employer to communicate their right. That is, whose right? The employee's right. These employees are laymen, they have not learnt law like us, so they don't know what are their rights. So employer's duty will be to communicate their compensation right. It should be displayed in English language also and Hindi language also, so that they will be able to read, or any other language in case the employee speak other language. How much penalty can be levied if there is any of the contravention? The penalty has been increased up to 50,000 rupees. Earlier it was 5,000, now it is 50,000. If employee is not happy with the compensation received, can they file a suit? Yes, there is authority where they can file a suit. And if employee is not happy with the decision, can they file an appeal? Answer is yes. Appeal can also be filed, but there has to be a minimum amount of compensation. So minimum amount of compensation should be 10,000 rupees, then only employee shall be eligible to file appeal. This amount has been increased now in order to reduce the litigation. So this is all with your Employee Compensation Act. Now let's start with the next act, that is Contract Labor Regulation and Abolition Act 1970. In chapter number 15, we have understood what is a contract labor. So if you're not done with your chapter number 15, let's understand it one more time. Now, there is an industry. Okay. Now in this industry, the employer is there. Okay. Now this employer, he appoints some employees directly. So employer employs some employees directly, and some he employs indirectly. Now how he can appoint employees indirectly? When he contacts any of the contractor. There is also one of the business where the person is a contractor and he will be dealing in the people. Dealing in the people, I'm not saying buying and selling of people, but the people will be appointed, employees will be appointed by this contractor. And when this employer shall contact the contractor saying that in my factory I want 500 people to be employed for 1 month. So employment is done indirectly by the employer. He is not employing, but contractor has appointed. So for these employees, who is a boss, who is the employer? The contractor. Okay, so these employees might not be knowing for whom they are working. They will be an impression they are working with this contractor. I hope you understood. So this is called as indirect appointment, and this indirect appointment is itself called as a contract labor. So when any of the laborers are appointed indirectly by the employer through contractor is called as a contract labor. So this act aims at regulating their appointment, abolition of contract labor in certain sectors of industry, and prohibiting contract labor in certain industry, because these laborers are exploited by the contractor. Hence it needs to be regulated, abolished and prohibited. I hope this is very clear. Now, where is this act applicable? This act will be applicable in any establishment where 20 or more contract workers are employed. Where 20 or more workmen are employed as a contract labor in preceding 12 months. It will also be applicable to the contractor where he is employing 20 or more workmen in the preceding 12 months. So this is applicable to both the contract labor, along with that the establishment which appoints the contract labor. Clear with this? So what is the object of this act? 3 things: regulate the employment of contract labor, abolition of contract labor, and prohibit employment of contract labor in certain industries. Now, whenever any establishment is employing contract labor, it becomes compulsory to register the establishment. So, if establishment is not registered under the Contract Labor Act, they cannot employ the contract labor. Clear with this? So, where 20 or more people are engaged in preceding 12 months, it becomes compulsory to register it. Okay, so without registering, there is a prohibition of employment of a contract labor. Okay, now this registration they have to do with the appropriate authority. Once appropriate authority is satisfied with your application, it shall grant you a registration certificate. Registration certificate is granted to the establishment, remember, because to the contractors they need to take license. So establishment who is employing the contract labor, they have to take the registration and contractors have to take the license. So registration which is taken by the employment, okay, can it be revoked? The answer is yes, it can be revoked by the authority which is issuing it. On what grounds? On the grounds that registration was obtained by misrepresentation or suppression of any important fact, not disclosing the important fact, or registration has become useless or ineffective because enterprise is not appointing the contract laborers. So in that case it may be revoked. But before revoking, your principal employer should be given opportunity of being heard. Without opportunity of being heard, he cannot be revoked. Also, along with the opportunity of being heard, they should take approval of appropriate government. Clear with this? This was registration of establishment. Going ahead to the licensing of the contractors. Contractors have to take license before they appoint the contract labor. So in preceding 12 months, if they are appointing 20 or more laborers or workers, then they have to take the license from the particular licensing officer. Okay. Along with the license, licensing officer shall give the conditions which contract labor has to follow and various welfare measures which they need to give. That means contractor needs to give to the employees. So hours of work, fixation of wages shall be done by the appropriate government. Can contract labor license be revoked? Why not? The authority who is giving license can be revoked that if it is obtained by any misrepresentation or suppression, or contractor fails to provide or contravenes any of this act. Very clear with this? Understood? As I told you, it will be duty of a contractor to provide various welfare measures. These are the welfare measures to be remembered. The first one, he should give canteen facilities where 100 or more employees are employed. So 100 or more employees are there, one or more canteen facilities has to be given. Now don't confuse this with your Factories Act, okay? Factories Act is different and contract labor is different. Both are different. Now restroom facility should also be provided where there is a requirement for employees to stay at night. So when they have to halt at night, employer should provide or contractor should provide with restroom facility. It should be maintained, restroom should be there, accommodation facility to be given. Along with this, he should also give the other facilities like sufficient supply of wholesome drinking water at convenient places, sufficient number of latrines, urinals, it should be away from the drinking water facility, also the washing facility to be there. Also there has to be a first aid box available during all working hours with the prescribed content. Okay, this becomes very important. So these are the welfare provisions applicable in the contract labor to be given by whom? Contractor to the employees. Okay, that's it guys. Only this much you have to learn in the Contract Labor Act. Now we shall start with the new act, that is the Industrial Dispute Act 1947. This is very interesting act, also little lengthy. So let's start. The name says it's an Industrial Dispute Act. So if we focus on this word dispute, what is the meaning of a dispute? Dispute means argument between two or more persons. Dispute does not mean the fighting and all, right? It's not a physical one. But when two people do not agree at one particular point, that is a dispute. So there is an argument. Okay? Different thoughts are there. So dispute means what? A disagreement between two or more people, I can call it as a dispute. So what is a dispute? It's a disagreement is a dispute. Now all disagreement are not covered under this, but another word to highlight is a industrial. So when we have understood what is a disputes, let's understand which disputes only pertaining to industry. So any person who are working in the industry, any disagreement is there among them, it will be called as an industrial dispute. So who all work in the industry? Employer, employee, right? So any dispute between them or any dispute between the employers inter se will be called as an industrial dispute. Now why it is important to solve them? In order to run the industry effectively. If we keep less number of disputes in our industry, if we redress it very timely, the turnover of employees shall be very less. Our output shall be amazing. Employees shall be always motivated to work in that particular industry where there are no disputes. So when there is a dispute, there is a problem. When there is no dispute, there is no problem. Hence, efforts are taken to solve the disputes. Now, which act takes the effort? Your Industrial Dispute Act 1947. Okay. This act came in the year of our independence. It is applicable to whole of India. What is objective of this act? The main objective of this act is to investigate and settle all the industrial disputes. So two important words, investigate and settle all kinds of dispute. First aim. Second aim, to secure peace and harmony. Okay, to secure peace and harmony in the industry. So how to secure peace and harmony? Whenever there is any dispute, if you redress that, it's an effort you're taking to secure peace and harmony. So for those dispute, providing machinery, also providing the procedure how to solve that dispute. Also providing for the various mechanism like arbitration, conciliation and other courts for the dispute. The third aim also deals with the retrenchment process of the employees, then procedure of layoff. All this is also included in the Industrial Dispute Act. Also, how to go for strikes and lockouts. And the last one, but very important one, it concentrates on the collective bargaining. It wants to promote that. Anybody's right is infringed, they all can come together and fight for that. That is a collective bargaining. If employer is not giving any of the thing which is entitled, I mean employees are entitled to that particular thing but employer is denying, employees can do collective bargaining against the employer. But yes, all means should be the legal means. So collective bargaining is promoted. These are the objects of your Industrial Dispute Act. So over here we are looking after the disputes. We will understand which dispute are covered over here. Before that, let's see what are the important definition. First of all, what is an industry? Industry means any place where business, trade, undertaking, manufacturing is going on. Employers are there, employees are there. It also governs service industry, employment, handicraft, industrial occupation, vocation of employment. Then industrial dispute. What is industrial dispute which is covered over here? The industrial dispute can be among three parties. Like first of all, industrial dispute between employer and employee. Okay, so first dispute between employer and employee, boss and the employee, simple. There is always dispute between them, right? The second one among the two employees, so employees and employee. Okay, suppose any worker was working, okay, and another worker came from behind and not with intention but he just rubbed his shoulder against the other one. So the first employee says that he is trying to hit me. This is a dispute. So this kind of dispute happens. Okay. And the third one, between employer and employer. Inter se also, it's an industrial dispute. So these three are the dispute. Along with this, again one more thing is covered. Which one? Whenever there is any dismissal or retrenchment of an employee, dismissal or retrenchment of an employee, okay, and employee is not happy with this, employee is agreed with the decision of this. What is retrenchment? I am going to tell you. For now, remember, it's a removal of employee by employer. So employer has fired the employee from the services. So dismissal or retrenchment of employee from the services, employee is aggrieved. Can these lead to industrial dispute? So when there is an individual person, so these employees only one. So can you call it as an industrial dispute in case of individual employees dismissal? The answer is yes. Even this is covered under the industrial dispute. I hope this is very clear. This is the definition. Now let's go to our notes and quickly read it. What is an industrial dispute? It's a dispute or difference between employer and employer, first one. Employer and workman, second one. Workman and workman, which is relating to the employment or non-employment. Okay, but it should be connected to the terms of employment basically. And it also includes dismissal and the retrenchment. Who is the arbitrator? Arbitration, conciliation, you will be learning in detail in your jurisprudence. Okay, this is one of the alternate dispute mechanism. So in order to reduce the burden on the courts, there is a arbitration and conciliation evolved. So this is a settlement outside the court. So any person who goes for arbitration, the judge of the arbitration is called as a arbitrator. Okay, so umpire who gives decision is called as a arbitrator. What is a closure? Closure of industry means permanently closing down the industry or part of the industry. Who is an employer? Any of the company which is having control by state government or central government. So your state government or central government shall be the employer. If they have appointed authority, then authority is the employer. If no authority is there, then the head of department. If any of the company is governed by any of the local authority, okay, in that case the chief executive officer shall be the employer. If they have appointed the authority, then authority is an employer. What is a layoff? Layoff means what? If I am employee of A Industries, I went to work, okay, at 9 a.m. There was a breakdown of machinery. Machinery was not working, okay, and that was the only machinery available. All the workers were sitting like that only. So when there is breakdown on machinery or there is no electricity or any of other problem from the employer side, so employer is not able to give work to the employee, and this is a temporary basis. So employer has to say, employee, you go home because there is no work. So inability of an employer to give work to the employee is called as an layoff. Please remember. So it refers to refusal, failure, inability of employer to provide work due to shortage of coal, power, raw material, breakdown of industry. This is called as an layoff. What is a strike? Strike everybody knows, right? In the layman's language we have heard. So whenever employees are not happy with the employer, in spite of giving so many notices, the employer is not listening to them, they may go on a strike. How to go for a strike? Which industry can go for a strike? Detail we are going to learn. Okay, so what is a strike? cessation of a work of any body of person, there has to be a group of people. How many, that is not defined. Okay, can one individual go on strike? There is no definite person written that how many can go for strike. Okay, but that should have a significant influence on the management, then only you can regard it as a strike. I hope this is very clear. So cessation of the work or refusal to do any of the work is called as a strike. So who does strike? Strike is done by the employees. Okay, and lockout is done by the employer. Okay, who does lockout? Employer. So irrespective of giving warnings so many times, employees are not listening to employer. Now employer do not have anything else to do but he go for lockout. So what he does, he locks the door. He will not allow any employee to come inside and work. That is a lockout, because irrespective of giving the warnings, employees are not listening. To teach them lesson, employer goes for lockout. Okay, so it refers to temporary closing of place of employment or suspension of work or refusal by employer to continue to employ any of the workmen. Then what is a retrenchment? Retrenchment refers to removal. If you know, in one of the US based company, one person, employer, fired 900 employees over the Zoom meeting. Okay, so this is a retrenchment. So how did he address that? Whoever is there in this call, from today their employment is ceased. That means you are no longer employee. I hope you understood. So retrenchment means permanent removal of employees by employer. It can be for any reason, maybe cost cutting, maybe any other reason. Okay, so over here employee don't want to go out, but compulsorily employer terminates the employment of employee. This is a retrenchment. So termination of service of workmen by employer. But over here voluntary retirement, resignation is not covered. I hope this is clear. Then works committee, conciliation and settlement. This will be learning when we'll be doing the different kinds of dispute mechanism. Let's learn the settlement over here. Basically, what is a settlement? Settlement happens in conciliation. Conciliation is the amicable means to settle the dispute. So there is a officer, okay, who will be doing the settlement, called as a conciliator. So conciliator is a friend to both the parties. Okay, he acts as a friend and he forces both of the parties to meet at particular point. So whatever dispute is there, please finish off the dispute, and then he makes party to enter into a settlement agreement. So in conciliation, there is nothing called as a award or judgment is not given, but settlement agreement is entered into by both the parties that both of them agree at particular point. This is a settlement. I hope this is very clear. Now coming to the last one, dismissal etc. of individual workmen. Can it be deemed as an industrial dispute? The answer is yes. I have already explained you this, right? So whenever any employee is removed without his consent and employee is not happy, when that leads to industrial dispute. So however, number of employees are not important, but there is a disagreement between two parties, it's an industrial dispute. I hope this is very clear. So this is all for your introduction and the definition session. Now let's start with the next provision, that is dispute settlement authorities. In the last video, we have seen what is an industrial dispute, also what are the other definitions under Industrial Dispute Act. Now this video very important. Why it is important? Because in this video we are going to learn very main part of this act, that is various dispute settlement authorities. What is the aim of this act? The aim of this act is to keep peace and harmony in the industry. So whenever there is a dispute, it will always aim to investigate that dispute and end that particular dispute. So for ending that particular dispute, there has to be some mechanism. Can every point of time, can we go to the court of law? Can we burden court of law with so many disputes? The answer is no. So under various acts, our legislation has given alternative to the court of law. Okay, like when we talk about the company law, we have NCLT. When we talk about the environmental laws, we have National Green Tribunal. So all these are the alternatives given. In the same way, under Industrial Dispute Act, in order to reduce the burden on the court of law, there are various authorities under Industrial Dispute Act which helps to keep peace and harmony, and in case of a dispute, they help to bring settlement in that dispute. So let's start with the first authority. Some of the authorities are in-house, that is inside the factory, and some are external to the factory. So the very first authority we have is a grievance redressal committee. Okay, this grievance redressal committee is in-house. In-house means that will be in the organization itself. So it will be duty of every employer where 20 or more workmen are working to have a grievance redressal committee in the organization itself. I'll repeat, whenever in any organization 20 or more people are employed, it will be duty of an employer to appoint grievance redressal committee, and head of the grievance redressal committee shall be your employer. So where it is applicable? Grievance redressal is applicable where 20 or more workers are employed. Clear with this? Understood? So this is the first one. Details will be learning from the notes. Right now you understand in the ascending order, the lowest authority to the highest authority, who all are the dispute settlement authorities under this act. So first one we read was grievance redressal committee. It is in-house, applicable where 20 or more workers are employed. The second one again we have in-house, called as grievance settlement committee. Earlier one was redressal and this one is a grievance settlement committee. As I told you, again this is in-house only, and this will be applicable where 50 or more workers are employed. Okay, so where it is applicable? Where 50 or more workers are employed. Over there it will be responsibility of your employer to appoint a grievance settlement committee. So where 50 or more are there, do you think there is a need to have grievance redressal? No, only one committee is enough. Okay, so where 50 or more are there, only grievance settlement committee. Coming to the third one, we have works committee. Third one is works committee. Even this is in-house. So wherever there are 100 or more workmen employed, it will be responsibility of an employer to have works committee. Okay, so again this is in-house and it is applicable where 100 or more workers are employed. Okay guys, so these are 3 in-house. Okay, only 3. Now rest of them will be the external body, hence not appointed by your employer but appointed by your regulating authority. I hope this is clear. Yes, so let's look the first external one. The fourth one, we have conciliation. As I mentioned earlier guys, conciliation and arbitration is one of the alternate dispute mechanism in order to lower the burden on the courts of law. These are established. Okay, so when any of the workmen, if they don't want to go to the internal committee, fine, they can go to the conciliation for ending up their dispute. Very clear with this? Understood? So this conciliation, it is not in-house, it is out-house, that is external. So it is appointed by your appropriate government. Who appoints? Appropriate government. So irrespective of number of workmen and all, it will be there in each and every district. I hope this is very, very clear. Great. Now the next one, fifth one, we have a board of conciliation. A board of conciliation. Again, this is an external body. Okay, board of conciliation is also an external body, so appointed by appropriate government. Okay, so in this external body, there will be one chairman. So what is the composition? There shall be one chairman and minimum 2, maximum 4 other members. Minimum 2, maximum 4 other members. So what is the difference between the fourth and the fifth? Fourth one talks about the conciliator, only one person. And fifth one talks about the board of conciliation. So there will be group of conciliators. So group of conciliator, that means a panel of judges, is a similar kind of a thing. I hope you understood. This was a fifth one. Moving on to next, the sixth one. We have court of inquiry. Again, this is an external body, so appointed by appropriate government. Who appoints? It is appointed by appropriate government. Now this appropriate government may appoint one chairman and 2 to 3 officers for carrying out court of inquiry. Court of inquiry is just like your court of session under the criminal law. Okay. Yes. After that, the seventh one, we have labor court. Again, this is an external body appointed by your appropriate government. The next one, we have industrial tribunal. Again, external body. Industrial tribunal is same like your high court. And ninth one, the last one, just like our Supreme Court, we have national tribunal. Simple. So there are 9 dispute settlement mechanism. Each of them we are going to discuss in detail, but please remember, very important, out of 9, 3 are in-house, internal, where it is applicable, 20 or more, 50 or more, 100 or more. Others, starting from conciliator, board of conciliation, then we have court of inquiry, labor court, industrial tribunal and national tribunal. Along with this, we have one more called as arbitrator. So when any of the workers, there is a dispute and they have not filed their cases with any of the tribunal, that is, they have not filed cases with the labor court, industrial tribunal, court of inquiry, they can take the matter to the arbitration also, no problem. So arbitration is also available over here. Is there any difference between the arbitration and conciliation? The answer is yes, there is a lot of difference. So let's start with our notes. So first one, over here we have works committee, but I would like to start with the first committee, which is grievance redressal committee. Okay, yes. Grievance redressal committee, I'm on page number 382. Okay, what is grievance redressal committee? Where 20 or more workers are there, and what is grievance settlement? Where 50 or more workers are there. So over there, it will be duty of employer to appoint these committees. Okay, so grievance settlement we have for 50 or more. I hope this is very, very clear. In preceding 12 months. Okay. So it will be compulsory to have grievance settlement authority. Then in any industrial establishment where 20 or more workmen are there, to have a grievance redressal committee. Why? To solve the individual grievance. Grievance means problems. Okay. Now, What will be the constitution of this grievance redressal committee? The constitution will be, there will be equal number of representatives from employer side and equal number of representatives from the employee side. Okay, so this committee, it will have equal number of representatives from employer side and equal number of representatives from employee side. It should be equal, right? Yes. Okay, so they will be equal. Also, there will be one chairperson. Chairman will be there. This chairman shall be on the rotation basis. What is a rotation basis? Like every year, the rotation will be there, chairman will change. In one year, there will be chairman from the employer side, and in the other year, the chairman will be from the employee side. This is the rotation which I am talking about. Okay, and very important. Total number of members of this committee cannot exceed 6. Please mark it. And wherever possible, if there are 2 male members, there should be equal number of female members also. So at least half of them should be female. That is more important. This is just for the empowerment of women. So whatever grievance comes to this committee, they have to try and solve the grievances within 45 days of receipt of the complaint. If aggrieved party is not happy with the decision of this committee, it can file appeal with the employer. Okay, and employer will have to settle the dispute within 1 month. Is it clear? Everybody understood this much? Great. Now we are going to the next committee, which is works committee. Okay, yes, I'll tell you the page number also, don't worry. Page number is 379. So we are on 379. We saw 2 committees till now, grievance redressal and grievance settlement, right? Now the third one we are going for, works committee. Where is works committee applicable? Where 100 or more workers are working in any establishment in preceding 12 months. So 100 or more workers shall be there, where it will be responsibility of employer to appoint the works committee. What will be the duty of this works committee? Same, redressal of the disputes, and that will be time bound. Okay, in case of some dispute, that means if any of the party is not happy with the decision of works committee, they can file appeal with the employer also. So again, the same thing, it will consist of equal number of representative from employer side and the employee side. Then employers representative and employees representative shall be equal. Also workmen representative will be chosen from the registered trademark. Okay, so works committee will deal with day-to-day problems arising in the industrial establishment, whereas those 2 committees dealing in individual grievances, this is dealing in workers' problem in day-to-day. Clear? Understood? These 3 were internal committees. Now we are going ahead with the external committee. In that first one is a conciliator. So conciliation officer, only single person is there. So who will appoint? The appropriate government shall appoint a single person to carry on the redressal of the disputes brought to him. Very important about the conciliation is, this is amicable settlement of dispute. So your conciliation officer basically is not a judge, but he will be a friend to both the parties, and both the parties will influence to enter into a settlement. The details of conciliation you will be learning in your jurisprudence. So conciliation officer, what will be the duty? Only mediating, and he will act as mediator between the 2 parties to resolve the dispute. Okay, so whenever you are into any of the public utility services means like railways, buses, etc., which public uses it every day. Whenever there is any conciliation proceedings going on in the public utility services, those officers cannot go for conciliation proceedings. So whenever any proceedings are going on, any strikes, any lockouts are going on, they cannot proceed for any conciliation proceedings. Very clear with this? Great. Now, what will happen if conciliation officer fails to resolve the disputes? If he fails to resolve the dispute, he will have to report to the appropriate government, and he has to send that report within 15 days. So basically, there is a time of only 15 days available in order to solve the dispute. So if he is not able to solve the problem, appropriate government may refer the dispute to conciliation board or labor court or industrial tribunal or national tribunal. Clear with this? Where is that 15 days written? I will mark it for you. Sorry, it is 14 days, not 15 days. Okay, so he will have to report within 14 days of receipt of the report. Now, going to the duties. This question is asked, guys. This question is asked in paper. What are the duties of your conciliation officers? Please write this point wise. Remember it point wise. What will be the duties? Simple. Whenever dispute comes to him, first of all, he will hold the conciliation proceedings. Okay. So he will hold conciliation proceedings relating to strikes, lockouts in the public utility services. He will also investigate into the dispute, because without investigation, can anybody solve the dispute? The answer is no. Then conciliation officer should be very fair, and he should use the amicable way to solve the dispute. Dispute is solved or not solved, but he should send report to the appropriate government within 14 days of receipt of the dispute, and he should make them enter, that is make the parties enter the memorandum of settlement. This is nothing but an agreement between both the parties that whatever dispute was there is resolved, and both of them agree at one particular point. So in conciliation, guys, you know that there is no judgment given. Conciliator is not a judge, but he is a friend. So he will influence both the friends to agree at one point, and when they agree, there will be a settlement agreement drawn. Clear with this? After that, if he fails to settle down the dispute, then we will have to tell that to the appropriate government, and appropriate government may refer it to the any other court. Is it clear? Understood? Okay, so these are the various duties you have to write if asked in your exam. So this was your conciliation. Conciliation was external. Going ahead to the next dispute mechanism is your board of conciliation. So earlier there was only one conciliation officer, now there will be group of conciliation officer. And very important thing, guys, this group of conciliation will always be in odd numbers. Like in your cricket, your umpires are there in odd numbers, right? Because in case of tie, always we require a person who will give a casting vote. So this is why always conciliation board consists of odd numbers. Okay, so suppose there is any dispute between two workers. Okay, so each of them has appointed one conciliator. Those two conciliators will be appointing the third one who will have a casting vote right. Is it clear? Understood? Now, who appoints the board of conciliation under this act? It is the appropriate government who does that. So appropriate government shall be appointing the conciliation board wherever it is required in order to solve the industrial dispute only. So this board will be only dealing with the matters of industrial dispute. What is the constitution? I have already told you constitution, one chairman and other 2 to 4 members. Okay, and these members will represent the parties. Whoever are the parties, member will be representing them. Now, what are the duties of this conciliation board? Conciliation board shall strive to bring settlement of the dispute. Okay, it shall also investigate into the matter. It should induce both the parties to reach at particular point and enter the settlement memorandum. If it fails to do so, if conciliation board fails to do so, it has to make a report and report it to the appropriate government within 2 months. So within 2 months of receipt of dispute, it has to report to the appropriate government whether he is successful in solving the case or he is failed. Okay. Now that appropriate government may, in case of a failure, give that matter to court of inquiry or other labor court. Very clear with this? Understood? So this was your board of conciliation. Going ahead to the court of inquiry. Now court of inquiry again is appointed by your appropriate government. So they will take into account the industrial dispute. Okay. So when court has 2 members, 4 members, those members shall be appointing a chairman for them, because always a casting vote is required. So now what is the authority of this court of inquiry? Do they have suo motu authority? Can they take up the matter suo motu? The answer is no. Suo motu is not there. They have to only deal in those matters which are referred to them by the government. So those matters which are referred by appropriate government, court of inquiry will be only looking into those matters. And after matter is solved all within 2 months, they have to report to the government whether issue is solved or not solved. Now listen, court of inquiry is a court. So there will not be any settlement agreement. But in this court of inquiry, it shall give an award or judgment, you can say. Okay. So there will be judge who will be passing a judgment saying that this is our decision. Only in conciliation there is settlement. I hope this is very clear. Going ahead to the labor court. If any of the appropriate government thinks it may establish 1, 2, 3, 4 labor court, how much hour is it required? So what will be the duty or function of this labor court? To adjudicate the industrial dispute. What will be the duty? Adjudicate the industrial dispute. Which matters? The matters which are given in the second schedule. Okay, so which matter labor court looks into? Matters which are given in the second schedule, point to be noted. Okay. After that, the next comes is industrial tribunal. Now industrial tribunal is again appointed by your appropriate government. So if in any state, if it thinks there has to be 1, 2, 3 industrial tribunal, it may appoint industrial tribunal. What will be the duty of industrial tribunal? To adjudicate the matters given in second and third schedule of Industrial Dispute Act. What will be the duty? To adjudicate and settle the disputes given under second and third schedule of this act. Now the composition becomes important. What is a composition of industrial tribunal? Industrial tribunal will have only one person. Only one person. He will be the presiding officer of the tribunal, like judge of the tribunal. And who can be judge of this industrial tribunal? The person who was or who is judge of high court. Okay, so judge of high court can be a judge of industrial tribunal, or he has 3 years of experience as a district judge or additional district judge. Okay, minimum 3 years of experience as a district judge or an additional district judge, or he is or he was a deputy chief labor commissioner. Okay, he was or he is deputy chief labor commissioner at the central level or joint commissioner at the state level. Okay. Along with that, he is having degree in law. Along with that, he is having degree in law and 7 years of experience working in labor department. 7 years of experience after working in labor department, and also 3 years of experience as a conciliation officer. So all these are the requirements of your industrial tribunal judge. One more requirement, even officer of Indian legal service of grade 3, even he can be the judge of industrial tribunal if he is having 3 years of experience in that grade. Clear? If you will read this 2 or 3 times, you will easily remember. Very important from exam point of view. Going ahead. Now, which matters labor code takes? Second schedule. Which matter industrial tribunal takes? Second and third. But labor code and industrial tribunal, they cannot take up the matter which is already taken by the national tribunal, because national tribunal is like your Supreme Court. Can anybody touch the Supreme Court? The answer is no. Okay. Now going to the national tribunal. National tribunal is appointed by your central government. Why? Because it is at the central level. Hence, appropriate government will not be appointing, but who appoints national tribunal? Central government, that too by giving notification in the official gazette. Can there be more than one national tribunal? Why not? There can be 1 or 2 national tribunal, but what questions or what matters they will be looking into? They will be looking into matters about industrial dispute which is having national importance. First of all, let's underline, very important, which is having national importance, means entire India is dependent. I mean, entire India's judgment will be dependent. So it is going to affect entire India, and it is also going to affect 2 or more states. The conjunction used is or. So which matters it can look upon? Matters of national importance or affecting 2 or more states. Clear with this? Understood? Going to the composition. Only one person will be appointed as a presiding officer of National Tribunal. He must be the judge of High Court. He will be the chairman. Okay. If he is not judge of High Court, at least he should be member of Labor Appellate Tribunal for a period of minimum 2 years. In order to help this presiding officer, your central government may appoint or more person to assist him. But who will give the judgment? Only and only this one person, presiding officers. Okay. So these were the dispute settlement authority. Now one more we have, as I told you, along with the courts we also have the arbitrators. So arbitrators, as I told you, it is an alternate dispute settlement mechanism. Okay. Why am I writing this here? So who can go to this arbitrator? Only those workers or those employers, there is a dispute and they have not approached any court which we read about. So they have not approached court of inquiry, labor court, industrial tribunal or national tribunal. So these people can take their matter to the arbitration. When you want to take matter to the arbitration, it's very important there has to be an arbitration agreement. So there has to be an arbitration agreement if you want to take your matter to arbitration. So before any of the parties to the suit, if they go to the arbitration, they should enter upon arbitration agreement, then only they can go for it. Understood? Clear? So whenever there is any industrial dispute but they have not referred to any court of law, they can go to the arbitration by entering into arbitration agreement. Is it clear? Now who can be the arbitrator? Any presiding officer of labor court, industrial tribunal, national tribunal can be the arbitrator, no problem at all. So who will appoint? Your appropriate government shall appoint. Okay, and what about the number of arbitrators? Like your conciliation, the number of arbitrators are also always in the odd numbers. Why? Because there has to be somebody who should be giving casting vote, right? So they are always odd in number. So when two people are appointed, then umpire shall be there who have power of casting vote. Okay, this umpire have right to give arbitration award. What is arbitration award? The judgment. What is the award? It's a judgment of arbitration. So in conciliation there is settlement, in court there is a judge giving judgment, even in the arbitration there is a judgment, but what that judgment is called? It is called as award. Why it is not called as judgment? Because it is not the judiciary, that's why. Clear with this? Understood? Okay. So arbitration agreement should be signed by both the parties. Then arbitration agreement has to be given to the appropriate government, and appropriate government, once it receives, it shall publish that in the official gazette. So once it published in the official gazette, your arbitration has started. So you have to complete the arbitration again within 2 months. So you have to give your award within 2 months. Okay. So arbitrator will investigate into the matter and give the award. The award or the judgment will be signed by arbitrator or more than one, then all the arbitrators should be signing the award. So whatever dispute has been referred over here, okay, if there is any strike or a lockout going on, then dispute cannot be referred to the arbitration. Is it clear? So these are your dispute settlement authorities under this act. I hope you have understood all of them. All 9 and one more. Arbitration is 10th one. Important from your exam point of view to revise it. So now we are going to start with the next provision of this Industrial Dispute Act, that is strikes and lockouts. Okay, what is a strike? As we read in the definition, strike is done by your employees or workers. So whenever there is any non-fulfillment of any demands which is given by your employee, they go for the strike. Can they directly go for the strike? No. First of all, they will place the demand before the employer. If employer does not listen, they will give him notice. Again, if he does not receive, if he does not listen, then the final notice, and in that notice they should write that we are going to start strike if you don't fulfill our demands within so and so days. Again, if that person does not listen to you, then only employees can go on the strike. Same is the case for the lockout also. Lockout is done by whom? Lockout is done by your employer. So when employer is giving so many warnings to the employee to do a particular act, but they are not listening, and after that he also issues final notice saying that if you will not listen to me, I am going to announce a lockout from this day. So when such notice is given, after that number of days are gone, if employees do not listen to the employer, in that case employer can announce lockout. Lockout means it's a temporary refusal by employer to give any work to the employee. This temporary may ultimately also reach the permanent. I hope this is very clear. So there are different provisions or different compliance to be done before going for the strike or lockout, especially when strike or lockout is done by public utility services. Okay, strike or lockout is done by whom? The public utility services. So whenever any strike or lockout is done by public utility services, they have to first comply with certain conditions. Okay, so now what are the conditions? This is all we are going to see. So strike is done by whom? employees, don't get confused, and lockouts is announced by employer. So before going to what are the conditions which public utility service have to do, first we will understand what is this public utility service. Okay, what is public utility service? Any service which is very important for the public, like water, electricity, buses, transportation, it will amount to public utility service. So they have defined specifically, we have to remember specifically. So the very first one, we have railways, road transport, that is roadways, air transport. Okay, these are essentials. Water transport are not covered. Okay, these three are covered. Apart from that, in the second one it is covered major docks and port, where transfer of passengers along with the goods and services are done. Apart from that, we have postal services, that is post services. Then we have telephone services. Then we have power and water supply. Okay, all this amounts to the public utility services. You have to remember this by heart. Simple, understood. This is definition of public utility services. Now going ahead, what conditions they have to comply before going on strike or a lockout? So first question is, can public utility services, PUS I am writing for public utility services. So can any of the employee or employer who are into public utility services, can they go for strike or a lockout? The answer is yes, they can go, but subject to certain conditions. They have to comply with certain conditions, subject to certain condition. So these conditions are only and only for the public utility services. Remember, it is not for any other services. What is the first condition? They need to give advance notice. Okay, advance notice of 6 weeks is required. How much? 6 weeks advance notice is required that we are going to go on strike. That's why whenever any autos or any of the buses go on strike, we know it prior to that only. Can we have a surprise strike? No, we cannot have that. Just imagine if railways go for toss, what will happen? Entire Mumbai will be over. Nobody can go for work, right? So this is the importance of public utility services. So advance notice of 6 weeks is important. Then they cannot initiate strike. They cannot initiate strike or a lockout within 14 days of giving notice. Okay, within 14 days of giving notice. So they cannot go on strike or lockout within 14 days of giving notice. Now the next condition, the date which they have mentioned that on this day we will go on strike or lockout, that day should be over. So for example, if any of the employees says we will go on strike from 1st of Jan, 1st of Jan should get over, from 2nd they can go on strike. Okay, so date mentioned for strike or lockout, I am writing S or L, that day should expire. What should happen? That day should expire. Then if any of the conciliation proceedings are going on, if any of the conciliation proceedings are on, they cannot go for strike or a lockout. Cannot go for strike or lockout. Clear with this? Everybody understood? Anybody having any doubts in this? After that, the next condition is, once conciliation proceedings are also over, okay, after conciliation proceedings are over, after 7 days of that also they cannot go for strike or lockout. So during the proceedings not allowed. After completion of proceedings immediately they can go, but after 7 days of that not allowed. Okay, yes, so after 7 days cannot go for strike or lockout. Is it clear? Understood? So these conditions have to be seen or observed by whom? Only public utility services. For other like private or other public sector which is not a public utility services, they can go on strike even without giving notice, no problem. But there are other conditions. So what are the conditions? We are going to see that from our notes. Yes, so there are certain general prohibitions for strike or lockout. These general prohibitions, it is for other than public utility services. It is not for public utility services. So except of public utility services, if any other establishment want to go for strike or lockout, these are the prohibitions where they cannot go for strike or lockout. So the first one is, whenever any conciliation proceedings are pending. So conciliation proceedings are going on, they cannot go for strike. And after 7 days of completion also they cannot go on strike. Okay, so if they want to go on strike, either before or within 7 days of completion of conciliation proceedings. After that, if any of the proceedings are pending before labor court, industrial tribunal or national tribunal, during pendency cannot go. After 2 months of the proceedings also cannot go. So immediately after the proceedings, if they are not happy with the decision, they can go on strike, no problem. They can go for the lockout also. But after completion of 2 months after proceedings, they cannot go for strike or lockout because already the issue is over, right? Okay, and if you're not happy, go for strike or lockout immediately. Why you're keeping space of 2 months in between? Understood? That is a logic. Again, same thing is applying for the arbitration also. If somebody is not happy with the decision of arbitrator, then immediately after arbitration proceeding is over, go for strike. After 2 months of that cannot go, and pendency of arbitration proceedings cannot go. Very clear it is? Great. Now, what is illegal strike or illegal lockout? I will explain this concept over here. When any of the public utility services, they do not follow any condition, these conditions are given, if they don't follow any of the condition and if they go on strike or lockout, that will be called as illegal strike or illegal lockout. So without observing the conditions, if any of the public utility service employee or employer goes for strike or a lockout, it will be deemed to be illegal strike and lockout. Clear with this? Understood? Now, in furtherance of this illegal strike, for illegal strike, the employer goes for lockout. For illegal strike, employer goes for lockout. And when illegal lockout is announced, employees go for strike. So in furtherance of illegal strike, if it leads to lockout, even without observing condition, it will not amount to be illegal. This will be deemed to be legal. Understood? Clear with this? Why it is legal? Because it is in furtherance to illegal strike or a lockout. Same provision is applicable to other enterprise which is not a public utility services. When they have to observe the condition, right? If they break any condition, it is a legal strike or illegal lockout. And in furtherance of that illegal strike or lockout, if any employer does lockout or employee does strike, it will not be illegal. I hope this is very, very clear. So this is end of your Industrial Dispute Act 1947. We are done with this chapter. Now let's start with the next act, that is Maternity Relief Act. Earlier Maternity Relief Act was of 1961, but yes, now there are various amendments and that amendment has come in 2017. We know that major changes happened in this law in 2017. Because of that, the leave during the maternity has been increased now to 6 months. So this is what we are going to learn. Only few things you have to remember. I'll be marking it for you, so make a note of it. So first of all, the Maternity Benefit Act 1961, Amendment 2017. It is applicable to whole of India. Now, where is this act applicable? This act is applicable to all the establishment, be it a factory, mine, plantation, government establishment, shop, establishment. It is applicable to all the establishment. Okay. Now coming to the definitions of the appropriate government. As far as any person who is employed in equestrian or acrobatic or any of the gymnastic performances, acrobatic and all means gymnastic performances, for them the central government will be the appropriate government, and for any other cases the state government. Who is a child? Child includes a stillborn child. Stillborn child means dead child. Okay, so child is born dead, that is a stillborn child. Apart from that, who is an employer? This definition we have learnt many times. When any organization is controlled by the central government is an organization, central government is an authority, or any authority, that means central government has appointed supervisor for that. So in that case, supervisor will be an employer. But if supervisor is not appointed, in that case the head of the central government will be the employer. Any of the enterprise who is controlled by the state government may have also employed the supervisor. If not employed supervisor, in that case the head of the department shall be the employer. In case of any establishment which is controlled by local authority, so local authority may have also appointed supervisor. If not appointed supervisor, then the chief executive officer of authority shall be the employer. Then in case of any other person, when institution is a private institution, then in that case we have to see who is having ultimate control. So whoever is having ultimate control, that person will be called as an employer. Now coming to the definition of the wages, you can just read it once because this is not there in your syllabus. Okay, just read it once, not required to be done. Now, what are the rights? See, when any of the lady, okay, she is working somewhere and she is pregnant. So, during the delivery process or before that, that is last stage of her delivery, she should take a rest. With intention of this and also for empowerment of women, government has made many amendments in the act. So, what are the provision? We are going to see that. Any woman who is employed, she will get a maternity leave of 26 weeks. So what is a maternity leave available? She is having maternity leave of 26 weeks. How many weeks she is having? Please remember, it is 26 weeks. Now in this 26 weeks, only 8 weeks should be prior. Okay, only 8 weeks should be prior. I'll explain you like this. See, this is a date of delivery. Okay, and total available leave is 26 weeks. So before this date of delivery, how much leave she can take? Only 8 weeks. Okay, and after the delivery, balance. I hope you understood. So before delivery, if she wants leave, she can take, but only 8 weeks leave. Clear with this? Okay, but there is some requirement. If woman join today, immediately she can get a leave? No. She should be working for at least 80 days in previous 12 months. So in the year, whenever she wants maternity leave, in the previous financial year, she should be working at least for 80 days in that organization. Only after that she can get the maternity leave. I hope you understood this. So what is the maximum period of leave? 26 weeks, and not more than 8 weeks can precede the expected date of delivery. Please remember. Now, suppose woman dies during the delivery. So will she get the entire amount till 26 weeks? The answer is no. Benefit she will take only till the date of her death. Okay? Benefit will be given to woman only till date of the death. But suppose woman leaves a child. Woman leaves a child. In that case, she will get the entire 26 weeks delivery. Understood? So when woman dies and there is no child, no living child, in that case, only till date of the death. Okay? In case woman dies leaving behind a born child, a live child, then entire 26 weeks can be given to the woman. I hope this is very clear. Great. Notice of the claim is not applicable to you. What will happen in case of death of a woman? I've already told you, employer has to give it to the woman. In case of a death, the legal representative of the woman. Okay. So first of all, it will be given to the nominee. If there is no nominee, then the legal representative. Okay, very important from your exam point of view. Kindly make a note of it. In case there is an adopted child, okay, in case woman has adopted a child, or or in case of third child. See, basically 26 weeks benefit any woman will be getting only for 2 children. For the third children, she will not be getting all these facilities. So for adopted child and in case of a third child, when other two are living, or they are alive, that means this is the third child, right? So they will get benefit or maternity leave of 12 weeks. How much maternity leave will be available in that case? Only 12 weeks. I hope you understood. This is what you have to remember. Okay, so let's sum up. Maternity leave is for encouraging women, empowerment of women to work. After that, maternity leave maximum 26 weeks, not exceeding 8 weeks before the delivery. Eligibility for this maternity leave, at least 80 days working in the preceding financial year. If child is adopted or in case of a third child when two are alive, only 12 weeks leave will be there. And it will be duty of an employer to provide every woman with this maternity benefit. And this leave will be the paid leave. So I hope this is very, very clear. That's it with the chapter. I told you chapter 17 looks big enough, but only important things you have to remember, then this will become very easy. Now let's start with the Child and Adolescent Labor Prohibition and Regulation Act 1986. Now this act relates to two people. One is child, another one is adolescent. Both of them should be going to school, completing their education and not allow them to work. But yes, there are certain families which require their children to work in order to live their life. So there is a law for this. Before going to the law, there is an act which came in 2009 which talks about right of children to go to school and go for education. So as per them, it becomes mandatory for all the children under 14 to go to school. Okay, so this act prohibits employment of children in any of the enterprises unless they are their family enterprises, and it also regulates the working of adolescent. It also prohibits the adolescent employment in any of the hazardous process or hazardous products. So going to the aim of this act. What is aim of this act? Prohibition of engagement of children in all the occupation. So children will not be allowed to do any kind of occupation except of certain exception under this act. Also it prohibits engagement of adolescent in certain enterprises. Certain enterprises means in hazardous occupation or where hazardous process is going on. Now what is hazardous process? The definition given in schedule 4 of this act. Okay, we are going to learn that. So any adolescent will not be allowed to work in the hazardous process or hazardous occupation. It is prohibited. Can they work in the other organizations? Yes, except of hazardous they can work in the other organizations. Also, children should enroll in the school. It will be their prime duty to take the education. Also, it regulates the employment of adolescent. So this is our act. First of all, we will learn section number 3. Section number 3 prohibits employment of children in any kind of organization. So none of the organization can employ any child who has not completed 14 years of age. But there are certain exceptions to section number 3. The exception says that when child is helping its family, okay, so wherever family is doing any work or where there is a family enterprise, the family has its own business, so that is a family enterprise. So if it is not hazardous process, then child can help the family also in the family enterprise, but this help can be taken only after the school hours or only during the vacation. Child will not be allowed to work in the hazardous also during the school hours. Okay, second, even child can work as an artist in our audio visual entertainment industry. Like we have seen advertisement where child performs. We have seen various reality show like dance shows, singing shows where child performs. So this is allowed because of exception given in section 3. So child can perform, but also we should make sure it is not hampering or affecting its school education. So if question comes, can child work in any advertisement? The answer is yes, because of exception in section number 3. Now when we saw section 3, there came the word family. So we have to learn the definition of family. What is a family? Mother, father, brother, sister. Then father's brother and sister, mother's brother and sister. I hope this is very clear. This is a family. Now going to section 3A. Section 3A talks about prohibition of employment of the adolescent. Now who is adolescent? Who has completed 14 years but not completed 18 years of age. So such person cannot be employed in the hazardous process or any of the hazardous occupation. This is given in schedule 4 of this act. So what is the definition of hazardous? Hazardous means mines. Hazardous means inflammable substances or any of the explosive. Hazardous means any other process. This is the definition of the hazardous. So I hope this is very clear. Children not allowed to work in any establishment. Adolescent not allowed to work in the hazardous process. So let's see our section 3. No child shall be allowed to work in any of the occupation except it is working for the family, school or government recognized organizations. Now we are going to hours and period of work. As we saw that child can work, adolescent can work, how much they can work. The conditions of service are also regulated. So no adolescent, no child should be forced to work for more than 3 hours at one stretch. After 3 hours compulsorily they need to take at least 1 hour break. Okay, how much break is required? At least 1 hour break will be required after working for 3 hours. So total spread over in a day, that means including the break, how many hours they can work. Including break, they can work not exceeding 6 hours. So per day how much they can work? Only 6 hours including hour of a break. Okay. Also they cannot work in night shift. So they will not be allowed to work between 7 p.m. to 8 a.m. They will not be allowed to work overtime. They cannot work in double shift or double employment. So when child has worked or adolescent has worked in one employment, he cannot go and work in the other establishment. Clear with this? Okay. As far as weekly holidays are concerned, all adolescent who are working, all child who are working, they should be entitled to a day holiday per week. And that should be entire day holiday, 24 hours. Can employer change the day of holiday? Yes, he can do so, but only once in 3 months. He can do only once in 3 months. And he has to exhibit that this day is a holiday. That means generally when factories are there, whenever they have electricity cut, they keep that day as a holiday. So say for example, Friday is a holiday. So they should exhibit in the language whatever your employee understands in the legible way that Friday is a holiday. Now, it will be responsibility of every occupier in the establishment whenever he is engaging any child or any adolescent. He should give notice to the inspector. This inspector is nothing but your factory inspector. Okay, he should give notice. See, this act, okay, this act came in 1986. So before that we had other industries, existing industry. So whoever were employing child or the adolescent, they had to give notice under this act within 30 days of commencement. And what all particulars they had to give? Name and situation of your establishment, name of the person who is in actual management, address where communication is to be done, and how is the nature of your occupation. Then other establishment which came after this act, it will be their duty to give notice to the inspector of the respective area within 30 days from date of employment of that child or adolescent. In that same particulars are to be required which we saw earlier. When there is any dispute as to age, many children don't have the birth certificate because the parents are not there or any other reason. So when there is dispute of age, there will be a certified authority. We will require certificate from the medical authority, and whatever age is written in that authority shall be final. Now it will be duty of every occupier who is employing children or adolescent to maintain a register. In that register he has to make the following details mentioned. Also that register should be available for inspection during all working hours. So what all things he has to write? Name and date of child who is employed there, hours and period of work, along with that how much rest he is taking, what kind of work that child is doing, and other particulars as prescribed. Now it will be duty of every railway authority, port authority, every occupier to display in the conspicuous place or notice that none of the child should be allowed to work in the factory or any other establishment. Child labor is not allowed. This notice has to be displayed. In which language? In local language, also in the English language. Please remember. If we don't follow any of the section, that is section 3, section 3a, you have the penalties. So what is the penalty for infringing section 3? Penalty is minimum imprisonment of 6 months, which may go to 2 years, and fine 20,000 rupees, which may go to 50,000 rupees. In the second conviction, the penalty becomes double. Okay, so guys, this was your act. So now let's start with the next act, that is Prevention of Sexual Harassment of Women at Work Act Prevention Prohibition Redressal Act 2013. The earlier act was abolished and this new act has come up. Now why it has come up? Because we know that India is party to various treaties. Okay, and to keep up that conditions we need to alter our acts regularly. So one of the subject was about the sexual harassment. Because of various cases in India like Nirbhaya case, okay, which happened in December, also other cases, it has paved way that government of India should think on the protection of women, safety of the women. So they have made little stringent regulation, also appointed authorities in district level, also inside the organization, so that whenever any woman faces any problem at work, basically we are going to see over here only related to women at work. Okay, so when any woman is working in any of the organization and she has to face any torture, any of the sexual assault or harassment, she can directly contact and complain to that authority. Okay, so this act aims to provide safe working environment to the women also. Also, our Constitution of India gives us equal fundamental rights. Both men and women are given with the equal fundamental rights. So as men have Article 14 and 15, even women have Article 14 and 15. They have right to live their life, that too with the dignity. Okay, so Article 21 promises that every citizen, every individual shall have right to live with dignity in India. So sexual assault, sexual harassment at workplace is prohibited under the act. If anybody carries out such act, he may be convicted under this act. Also, he may be losing his employment. So sexual harassment is a violation of right to practice any profession or to carry on any occupation, trade or business, and it will be also right to have a safe environment free from sexual harassment. Now coming to the definition is little bit technical and lengthy, but if we mark the important points it becomes very easy to understand. So this definition has come from the Vishakha judgment. It says that the sexual harassment includes any unwelcome acts or any behavior. It can be physical, it can be directly, it can be indirectly. By physical means, by advances, demand or any of the implied act, request for sexual favors or showing sexually colored remarks or showing the pornography as well. Other unwelcome physical contact, verbal, non-verbal, everything comes under the sexual harassment. Now this was a definition in the Vishakha judgment. In section number 3, it has defined that none of the women should be subjected to any of such uncomfortable situation of sexual harassment at the workplace. It is prohibited. So what will happen? How to identify that? If such circumstances is there, like any act or behavior of sexual harassment may amount to sexual harassment, such as it can be implied, it can be expressed. For any of the preferential treatment, boss tells the employee that if you give me sexual favors, I shall give you the preferential treatment. Even this is not fair. Or any of the threat which will be detrimental in the employment, like if the employee is not agreeing, then the boss may say that if you don't agree, I shall mistreat you in front of everybody, not feeling comfortable in the public, or threat about her future and present employment. Also boss can say that, or any of the other employee, not only the boss but any of the other colleague, any person who is working, that if you don't give the sexual favors then you may lose your job and we will make sure you are not getting any job anywhere. So this is interference with the work. and the woman will, or any of the person who is suffering, may feel like a hostile work environment. Hostile means somebody has kidnapped us. We will feel very, very humiliating. This affects the health and safety of women. So this is not allowed. Okay. Now, as I told you, there is a machinery where the dispute can be taken. So one is internal, one is external. Internal one is internal complaints committee. There is something called as internal complaints committee. This is inside the organization. So where it is applicable, where 10 or more women are working, it will be compulsory to form internal complaints committee, and it will be responsibility of employer to constitute such committee. The head of ICC would be a woman only. If woman is not there in particular branch, from any branch, but head of this would be the woman only. Okay, so it becomes mandatory for employer to constitute internal complaints committee, where the complaints made by agreed women would be entertained. And what will be the composition? There will be a presiding officer. Presiding officer should compulsorily be a woman. Along with that, minimum 2 members from among the employees, preferably who knows the cause of action or who has experienced such earlier. So 2 or more from the organization, and 1 member will be from NGO who is dealing with such kind of organization, who is committed for the cause of women, protecting the women and issues relating to the sexual harassment. So your judgment should be impartial. Okay, for that effort should be made that at least one half of the members of ICC consist of women, because only women understands another woman. And this is the LCC. This is a local complaints committee. This is not in-house, but it is external. Okay, so this is external authority. So who makes this or who establishes this? We have a district magistrate. Okay, district magistrate would be responsible for constituting this local complaints committee. So who can go to this local complaints committee? Any of the women who has complained against the employer. Okay, employer is only harassing, then how she is going to go to that ICC? Or where there is no ICC, because only 10 workers are there, so no ICC is there. So any of these cases, women can file a action with LCC, that is local complaints committee. So it will be there in every district. So what is a complaint filing procedure? Women only have to file a complaint, and that will be a written complaint, either ICC or LCC. What is the time limit? Women have to file complaint within 3 months of that event. If event is very repetitive in nature, it has happened a lot of time, then 3 months from last incident which happened. So time limit is only 3 months. Under this act, can women file a criminal suit? Yes. If the cause is very, very serious kind of, instead of going here, they can directly file a case in the criminal court. Okay, when that is allowed. After that, if woman is not able to file complaint because of any reason, a reasonable assistance should be provided to her. Assistance will be provided by your ICC, presiding officer, or any member of that, or your LCC. So they should make sure that woman is able to write complaint. Now, if woman is not able to file complaint because of her physical health, she is not in that power to write a complaint, then with a written consent from that woman, anybody can file a complaint on behalf of her, but we require a written consent from her. So who all can file complaint on behalf of women? Relative, please underline, friend, or her co-worker or any officer of National Commission for Women or State Women Commission, or any person who knows that incident, who has seen that incident. Okay, so on behalf of women, these people can also file, no problem. But a written consent of women is compulsory. Hence, it will be duty of an employer to provide with the safe and good working conditions to all the women and take care of all this efforts and take care of all this action going on in the organization. Also, it will be advisable to the employer to put a prohibition in the code of conduct only, that if any employee does any of such act under Sexual Harassment Act, he may lose his job. Understood? So that's it, guys. We have done with our chapter number 17. Okay, I understand there are many laws which we have read, but if you make a flow chart of this chapter, it becomes very easy to understand. Now we are going to start with our next chapter, that is Rights of Disabled Person Act 2016. Okay, so I understand your chapter number 17 is little lengthy, but it has huge weightage. So out of 35 marks, we can expect at least 15 to 17 marks from this chapter number 17. So one of the chapter in your 17 is Right of Disabled Person Act 2016. Now there was a similar kind of act governing right of disabled person before this act. The name of that act was the Person with Disability Equal Opportunity Protection of Right and Full Participation Act 1995. This was a previous legislation. This has been repealed, and now after that we have a new act called as Rights of Disabled Person Act 2016. Now, why act was repealed and why this new act? As we know that India is party to various treaties, right, various contracts. So internationally we have to maintain certain standards. So to maintain the standards, we repealed the previous act and we constituted the new act. I hope this is very, very clear, all of you. Okay, so now this particular act, okay, this particular act, it governs right of the disabled person. Okay, it governs right of the disabled person. Now, what is a disabled person? A person with some disability, like his basic organs, or mentally, physically he is retarded, he is not perfect, he is not blessed. Okay, so he is a disabled person. The disability may be the physical, maybe mental, or any other kind of disability which is a barrier, okay, which is a barrier for his achievement. So let's go and proceed. So section 102 of your act, okay, section 102 of your act says that the earlier act was repealed and new act has come. Now what is the aim of your new act? It says that our constitution gives equal right and opportunities to each and every person who is in India, irrespective of being able or disabled. Hence, we are nobody to discriminate among them. So if we are able person, we should not tell that no, he is blind, he cannot go to school. This is wrong. So for protection of this rights, this law has come. So the preamble says that it holds dignity of every person in the society and prevent any kind of discrimination. Now students, from your exam point of view, this chapter is little lengthy chapter. I am talking about Right of Disability of Person Act. So I will be marking important things for you. You have to remember that much. Okay. Yes. So let's directly go to the important definitions. The very first important definition is a barrier. Barrier means something which is hurdle for you. Okay. So what is a barrier? which hampers full and effective participation of the person with disabilities in the society. So just because they are having disability, they are not able to participate in the society, be it cultural, be it economical, be it environmental, be it any other factor. Second comes is a discrimination. What is a discrimination? Just because one person is fair and the other is dull in color, the fair person cannot say you cannot sit with me for the dinner. That's wrong. This is a discrimination. This is not supported by Constitution of India. So discrimination as to disability, it's not allowed. It is infringing somebody's fundamental rights. Hence, if anybody does any distinction, extension, restriction on basis of the disability, okay, then that would be hampering the human rights and the fundamental freedom. Understood? It also includes discrimination in all forms. Denial of reasonable accommodation also is a discrimination. Understood? After that, who is a person with disability? Please remember this. They may ask this in your exams. Okay. It may be a person with long-term physical or a mental or intellectual or sensory impairments which on interacting with the barriers hinders effective and equal growth in the society. They cannot grow equally with the abled children. Then what is a benchmark disability? Disability are of various types. Benchmark disability means a person who is having huge disability and that person cannot live without anybody's support. So basically a person with benchmark disability requires support. Okay, so they have given a concrete number to it. So what is a benchmark disability? It's a 40% or more. Okay, this 40% or more, we have to take certification from a doctor. Doctor will give a certification that we are having benchmark disability of 40% or more, then only will be called as a benchmark disabled person. So 40% or more, in such case a disability has been defined in the measurable terms and includes a person with the disability. Apart from that, person with disability having high support needs. Person who is having benchmark disability, that person has high support needs. So Government of India provides them with this support, and once application is made to Government of India, this support is provided within year of 2 to 5 years. I hope this is very clear. Now let's start with the rights and entitlements. So what are the rights and entitlements available to the person with the disability? And it would be compulsory for all the people including Government of India to give them those rights and responsibilities. So what is the first one? It talks about equality and non-discrimination. Okay, so what is the first important point you have to mark? Equality and non-discrimination. Person with disability should not be discriminated on the grounds of disability, or other forms of disability are also not allowed in that. So they should be treated equally with the other people in the society. So what is important in section number 3? You have to remember right to equality and non-discrimination. Okay, so it will be duty of Government of India to ensure that person with disability, they enjoy same kind of equality, same kind of right to life, because as I told you earlier, Constitution provides us with the various fundamental rights. These fundamental rights are available to all the people irrespective of them being able or disabled. Okay, that's why it will be duty of government to take appropriate steps in this regard. Okay, also very important, if any society or any of the accommodation refuses any person to give them with the accommodation facility just because they are disabled, then also it is infringement of the rights of Disabled Person Act. Okay, so it will be duty of government to ensure reasonable accommodation to person with a disability. This was important marking in your paragraph number 1, section 3, right to equality and non-discrimination. Okay, so let's move to the second one. Second talks about section number 4. Section number 4 says that the section 3 right, that is right to equality and non-discrimination, it is also available to the disabled women and the disabled children. So even disabled women and children have this right of equality and non-discrimination. Apart from that, your section number 5. Section number 5 says that even disabled person have right to live their life with the dignity. Okay, so right to live life with the dignity in the society. So government should not be making special societies or accommodation center for disabled. Like you cannot have buildings only for a blind person, you cannot have building for a mentally retarded person. No, unless there is some specific requirement, government should provide them with the accommodation with everybody. They should not be discriminated just because they are disabled. I hope this is very clear. Okay, so they are not obliged to live in a particular living arrangement. Okay, so government should provide in-house assistance to assist such disabled person with the personal assistance and support their living. I hope this was very clear. Yes. After that, section number 6. It talks about protection of people with a disability. You might have seen many movies wherein they have showed that person with the disability, they have to suffer a lot because mental torture, physical torture. So all this torture should not be done. For this, it's a responsibility of a government. Okay, it's a responsibility of a government to protect them. So section 6 provides for protection against torture, cruel, inhuman and degrading treatment. Okay, and if government finds any of such these things, he should be punished. Also, he should prevent with the disability from being subject to any sort of research without his consent and informed consent. If any of the person who is disabled, any of the person stops him and saying that I want to search you, this is wrong. Okay, nobody should be searched just because he is a disabled person. So this is your section number 6. Then comes your section 7. Section 7 talks about protection of this disabled person against abuse, violence and any of the exploitation. Abuse, violence, any of the exploitation. Understood? Please remember this. And any point of time, any abuse, violence is done, government has appointed an executive magistrate for them. Okay, you will learn various hierarchies of court in your criminal law. Okay, so executive magistrate is there who will be taking matter into his hand. Okay, so this executive magistrate shall be responsible if he sees any violence, okay, and he notices, he has to take that matter under him, and it will be duty of executive magistrate to send the victim for the proper treatment and for proper investigation also. So it will be duty of magistrate to register complaint against that person, also to rescue the victim and provide him protective custody and maintenance of such person. After that, it will also be duty of a police officer whenever he comes across any of such torture which is happening to any of the disabled person, immediately he should reach the nearest executive magistrate and provide him with all the details and also provide that victim in a safe custody. After that, section number 8. Section number 8 talks about protection of the person with disability against any of the natural calamities. So when any of the natural calamity there in the state, like we have natural calamities like earthquake, flood, tsunami, etc., or any other calamities, we have a disaster management team at district level, state level, and the national level. This disaster management team, what they will do, they will keep a list of disabled person in their particular territory, and whenever such circumstances happen, they will make sure the people are rescued. I hope you understood this. So the district, state disaster management as well as national disaster management take suitable measures to maintain list of person with disability in a particular state. I hope this is very clear. After that, section number 9. It prevents any child with disability to be separated from its family. Just because their parents are disabled, child cannot be separated from its parents. And if any of such thing is done, the child should again be with his parents. Okay? So, except by order of the court, child cannot be separated from its parents. Okay? After that, suitable information should also be provided to this disabled person regarding the family planning. Okay, and if any hospital, any of the authority carries out any of the medical process and plays with the fertility of any disabled person, even that amounts to infringement of this act. I hope you understood this. So these are the certain rights, basic rights, that is protection against the torture, natural calamities, equality, non-discrimination. Now we are going to various constitutional rights. Okay. Now we are going to various constitutional rights. Now constitution also provides various rights. Everybody is aware of that. So section number 11, it will be duty of a election commissioner to make the disabled person aware of this election process and help them in voting. Okay. Second responsibility is given to the appropriate government to make legal process accessible to this disabled person. So if any of his right is contravened or taken away, he should have fair access of a legal person just like a abled person. Apart from that, section number 13 talks about legal capacity. Just because person is disabled does not mean he is not eligible to enter into a contract. If he is having proper mental state, he can enter into any contract and that would be legal enough to do it. Okay. Now we'll proceed with provision relating to the education. Now this question was asked in your paper. Okay, that is, what are the provision relating to the education of a disabled children. Now when we talk about the education, it is about the children. Okay, so part, that is chapter 3 of your right of person with disability, speaks about various provision relating to education of children with the disabilities. Okay, and also what are the duties of the educational institutions. So first one, duties of educational institution. This duty is been transferred to every state government. So it will be duty of every state government to make sure they provide with these facilities to the children with the disability. So first one, they have to admit children with the disability without any discrimination. So as far as state-run schools are concerned, they cannot discriminate between the abled or a disabled child. They have to admit all of them. Okay, so no discrimination. So admission without any discrimination, also provide them with the equal opportunity in education, sports and the recreation. The second point, state also have to make building, campus and other facility which will be needed by this disabled children, and this facility should be accessible to them. Okay, so building, campus and other facilities. Third, if any of the child require any of the specific support, the specific support on request of that child has to be given by every state. Apart from that, children who are deaf and blind, they cannot read and write or hear like the able children. Hence, they require special kind of books and teachers. So, specific arrangement has to be made for that. Then, any of the child who requires a transportation facility, so those transportation facility are also to be provided to the children. Now, going ahead to the section number 17. Section 17 talks about measures taken by your state government to facilitate the inclusive of education. So along with the education, they should also aim at providing this many things. So the first one, your state government should always do survey that how many special children are there in their particular area. Along with that, for these children, it should establish special schools, okay, and also train the teachers for them. Along with that, provide for books and assistive education, okay, providing of the books and also the education. Also providing them with the scholarship in order to motivate them. I'm always keep on researching how to improve their learning, and for that improving, it's important to improve the teachers training. I hope this is very clear to all of you. Okay. Now going ahead with the skill development and the employment. Skill development employment relates to the adults. Okay. Skill development and employment relates to the adult. So now any person who is disabled, okay, but he wants to earn his own living, it should be, always duty of a state to see to it that each of the person in a state who are able to do some kind of work, okay, they should be independent so that they are not dependent on any other's income. Okay, so it will be duty of the state to provide with some kind of a training to physically or mentally retarded people so that they can earn and they can live. So skill development, vocational training, self-employment scheme, these three things are there. So section number 19, it talks about creation of some vocational training. Okay, this vocational training and self-employment. Any person who wants to work somewhere, they should be provided with some kind of a training and vocational training as well. Okay, so skill development or the vocational training, if this is provided, they can work and earn out of it. Any person who is disabled who wants to do business, for them, government should aim for less interest loans. So providing loans to them, then also promoting their products. Okay, so this is very important. The first one, it talks about types of scheme which has been spoken about in section number 19. So first of all, inclusion of person with disability in any vocational or the skill development programs. After that, adequate support facilities provided to that person for taking that program nicely. Then any person who wants to do business, providing loans to them at the concessional rates. Also, marketing for the products which are manufactured by the differently abled person. Also maintain the data about the progress. So it will be duty of every state to maintain the data, how many disabled are employed and how many are not employed, and they have to always track what is the progress in them. I hope this is very clear, all of you. Okay, now let's proceed. Section 20. It states that whenever any person is disabled, just because he is disabled, there should not be discrimination as to the employment. So all the state-owned offices, they should give the equal opportunities to the disabled person as well. Okay, so no discrimination as to disability relating to any of the employment And near the employment they should also get the reasonable accommodation. Also, if there is any other barrier, okay, that barrier has to be taken out by the government. Okay, suppose that person is disabled and he is working in any organization, the profile is not suitable for him, so state should make sure that he is shifted to some other kind of work where he can do it comfortably. I hope this is very clear. Yes. So such arrangement can function till the time there is appropriate post for him. Then your section number 22, it talks about maintaining the records. Okay. So every state should maintain the record that what are the job opportunities for the disabled person. Like there is something called as employment exchanges. So in employment exchanges, wherever are the job opportunities, they take them. Okay. So this will be specially for the disabled person. Also in every state-owned enterprise, there will be an officer called as a grievance redressal officer. Okay. That grievance redressal officer shall be redressing the grievances of the disabled person. Okay, if any of the non-compliances are done. I hope this is very clear to all of you. Now this is all for the rights entitlement. We saw education, we saw skill development, vocational. So all these things are very important from our exam point of view. So please remember this. Okay. So now let's begin with the other relevant provisions of this act. I hope you're marking. Okay. Yes. So next one is a social security, health, rehabilitation and the recreation. Even it will be duty of the state to also provide them with the social security, health, rehabilitation and the recreation. Like we require entertainment, we require the health facility, also the disabled person require the same. So let's see what are the duties of the state in that. Community centers have to be established for them, okay, where they will get very good facilities as to safety, sanitation and the health care services. Along with that, facility should be provided for the children also when they don't have families or homes. Also, support should be given to person in case of a natural disaster. Okay, then woman should be supported if she is disabled with the children and there is nobody to take care of them. Also, there should be a wholesome drinking water available in the slum areas. Also, the comprehensive insurance schemes should be taken out so that whatever expenses are there as to their illness, that will be covered by the insurance company. So these are the 6 important points as far as social security, health, rehabilitation and the recreation is concerned. Apart from that, section number 25, it says that health should be a priority sector as far as the disabled person is concerned. So they should be making health free of cost. So wherever treatment is done, that should be done free of cost. Okay. They should also take various measures for training the staff, screening the disabled children, sponsoring awareness campaign because it's not easy to interact with them. Okay. Then they should also provide the rehabilitation facility within the government budget. Okay. Also, it also encourages government to initiate various research in the rehabilitation of such person. Okay, and they should also have a good life by way of various cultural program, event, recreational facilities, competition in order to motivate them, in order to have something good in their life. I hope this was very clear. Yes. After that, certain special provisions are made for the person having benchmark disability. So any person who is having a benchmark disability, okay, that person will be given this all facility. Benchmark disability means what? We have already read, a person who is disabled 40% or more. Such person will be called as benchmark disability. Okay, so there is a right to free education for children who are having benchmark disability right from 6 years to 18 years of its age. Okay, so from 6 years to 18 years, they have free of cost education. Then once they grow up, for the higher education also there are certain reservation in the government institution. So reservations are 5% or more seats are reserved for the benchmark disability. Also the cap on the upper age is increased. So for example, particular course was available till 45 years only, but for disabled person that course will be available up to 55. Understood? There is a upper age relaxation as well. Then it also instruct the government to identify various posts which benchmark disability person can do. Okay. Along with that, section 34 says that in the government establishment, at least 4% reservations are to be made for any person who is blind or having low vision, deaf or hard hearing, having any locomotor disability like cerebral palsy, leprosy which is cured one, dwarfism, acid attack victim and the muscular dystrophy. So for these people 4% reservations in the government institution. Please remember this. Then 1% total reservations in the government institution for these people, that is having autism, intellectual disability, specific learning disability and the mental illness, or any person having multiple disabilities. Okay, so 4% and 1%, total 5% in the government institutions. Please remember. Okay, then government also provide with various subsidies when any of the private enterprise like Reliance, Tata's, if they keep reservation of 5% for this disabled person, then government will be giving them various subsidies. Okay, so 5% reservation in the private organization, that private organization shall get government subsidies. I hope this is clear. Okay, Tata's provide for the percentage for the disabled, but it is not 5%, they keep 2% of the strength. Okay, then 36 talks about special employment exchanges for the disabled person only, so that disabled person can find out the job very easily. Then apart from that, various schemes are there under various land allocation. So whenever government allocates the land, so in allocation of land or houses also they give the priority quota, that is of 5%. So 5% reservation is there for allotment of agricultural land, housing related schemes, poverty alleviation and other developmental schemes. So everywhere even women will get the same priority like the men's with the disability. I hope this is very clear to all of you. Great. Now, there are certain special provision for disabilities with high support need. Now, who have high support needs? Children or any other person who have high support needs, the person having a benchmark disability. So, any person having a benchmark disability, they have high support need. Okay. So, what is their need? Any person who is a benchmark disabled, they cannot live without support. That support can be asked from the government. Okay, so government will not believe you. So government has appointed various certified authorities that are doctors. Those doctor will be giving you certification that you are having benchmark disability with high support needs. That certificate you have to submit with the government and government will assess that. If found suitable, it shall provide you with the all support facilities. I hope this was very clear. Great. Then there are other duties and responsibilities of the government also. Now what are the other duties and responsibilities over here? Government should always strive to encourage, support, promote and create awareness for helping this disabled, not to do discrimination, provide equal opportunity and solely program aims for merits and abilities of this disabled person. So this program should be done at various school, colleges level. I hope this is clear. Then it also aim to provide transport for the person with the disability. Okay, so Any of the benchmark disability with high support needs, they require a transport facility. So accordingly, transport facility have to be provided to them where you have a personal mobility as well. Okay. Then they should have access to information like mass media, newspaper, all the information. They cannot be deprived of this information also. Along with that, they also promote the production distribution of consumer products which are made by the disabled person. Also, they ensure that all the structures, that is all the support which is claimed by the benchmark disability should be available to them within 5 years. Okay. Then they also provide training to the all the social helpers, that is teachers, nurses, doctors, whoever are dealing with the disabled person, they provide with the special support to them. Okay. Then if any of the institution who wants to work for this disabled people, can they work directly? The answer is no. Institution who wants to provide some facilities to the disabled person, they have to take the registration first. What they need to take? Registration from the government. So when government grant them registration, then only they can work for the disabled person, provide them with the various facilities. Without that, they won't be allowed. Understood? Okay. So when any of the institution is agreed with the decision of the government, they can appeal also. Okay. Then certification of specified disability. As I told you earlier, when you are having a benchmark disability with high support needs and you want to grant and you want to ask support from the government, in that case you should be having that certificate. The certificate will be issued by the certifying authority. Okay. Then there are chief commissioners and state commissioners also. The chief commissioner and state commissioner are appointed district wise and the state wise. Okay, so what will be their duty? Their duty will be to look into the matters of the law, wherein they can make inquiry or take suo motu matters also, where any of the discrimination is done. Please remember, underline the important points. Where discrimination is done against such person, they also monitor implementation of this act. Also provide for the awareness of right of the person with the disability. So when the chief commissioner and the state commissioner does this, they have to prepare the annual report. Okay, and in the annual report, it will be given to the government. Both chief commissioner and the state commissioner have to make this annual report and they have to submit it to the government of India. Whenever they are taking up any matter relating to the person with disability, they have all the powers of the civil procedure code. Okay. Special courts are also made for this disabled person. Special court is the court of session. Please remember. Now you'll tell me, ma'am, then what was executive magistrate? Executive magistrate only looks after the torture, cruelty. Other matters are also there, right? When there is discrimination and when there is no torture. So where people, that is disabled people, can go and file a suit, they can go and file a suit in the criminal court, that is court of session. Okay, this court of session, who will be judging that? It will be advised by Chief Justice of High Court. In every district there will be a court of session. Okay, and also there will be a public prosecutor appointed. Then there is a national fund for the person with disability. So government maintains this at the national level, central government maintains, and at the state level, your state government maintains. I hope this is very clear. With this, we finish this chapter, right of person with disability. I know this is bit lengthy chapter, but markings are important. Please go through the markings and then the chapter will be very easy. Now we are going to start with the next act, that is Minimum Wages Act 1948. Now what is this Minimum Wages Act? As we know that our labor class was much exploited by the Britishers. They never used to make payment on time. or if at all they make payment, it used to be very less or sometimes even no payment. So our labor class was exploited and forced to work without remuneration or fixed remuneration. Hence, the Minimum Wages Act was passed in year 1948 just after the incorporation in order to fix the wages. So it will be duty of appropriate government. It will be duty of appropriate government to fix the minimum rate of wages. Okay, so for whom they will be fixing minimum rate of wages? For all the industry which are given in schedule 1. So basically the wages will be fixed for the scheduled industry. So industry which are there in schedule 1, they are called as a scheduled industry, and it will be duty of your appropriate government to fix the minimum wages for all the employees working in that industries and pay them on time. Okay, so no employer shall pay to any employee less than minimum rate of wages notified by your appropriate government. Now, how to fix the rate, we are going to see that little later. Who fixes that, we are going to see little later. But fixation of minimum wages of act, it is done for different departments and different bases. So first of all, as far as employment are concerned, for scheduled department, different rate. For different classes of work, different rate. For adults, adolescent, children, trainees, different rates. And any industry locating in different localities, so for different rates. So different rates are fixed for each and every this thing. Please remember, for different schedule employment, different classes of work, adult, children, adolescent, apprentices, and different localities. Okay, so your wages may be fixed on any of the following. So on the time basis, there are various kinds of wages like piece work, time work. Okay, so on the time basis, they have 4 options. It can be hourly payment, it can be daily payment, it can be even 15 days payment, or it can be monthly payment, but it cannot be exceeding month. Okay, so the maximum time period is month. We cannot have wage period more than 1 month. Now whenever this appropriate government is fixing the wages, they should keep various things into account. Which all things? How much is a skill of worker required to do any particular work? So whether your worker is unskilled, different rate, skilled, different rate, semi-skilled, different rate, highly skilled, different rate. Also where they are working, geographically located. In addition to this, there are also certain category of workers who work in very dangerous industries, like for example cotton openers. Some of the employees work in the artificial humidity, so it's not good for their health, so it is very dangerous. So temperature, humidity, it is not normal. Or some employees who deal with the hazardous occupation or process, some of them who work over underground, this all has to be taken care of when they are fixing the wages. Now, what is the procedure to fix the wages and revise the wages? As I told you, the authority is given to the appropriate government. So, appropriate government shall be fixing the wages, minimum wages for the scheduled industry. So, for this work, appropriate government appoints various committees and the subcommittees for fixing and revising the rates. It becomes very important to revise also. Okay, once these committees are formed, okay, then once report is made by this committee, they forward them to the appropriate government. If appropriate government likes the report with or without modification, they will publish this proposal of the wages in the official gazette. Okay, so when this is published, any number of people who are going to get affected in the industry, like employer employee, both of them have to give their comments, and this has to be given within 2 months of the proposal. So comments are welcome up to 2 months. Okay, always suggestions are taken. So whenever this suggestion come after 2 months, along with this advisory committee, okay, they make the final report. Once final report is made, again it will be checked by your appropriate government. If found correct, it shall publish in the official gazette. So once it is published in the official gazette, it shall become applicable, it shall come into force within 3 months of publication. Clear with this? This is how your minimum wages are fixed. And it becomes very much important to revise that minimum wages act. Why we need to revise the wages? Because of the inflation. Okay, any of the wages which are fixed for 2015, if you keep it stagnant up to 2050, who is going to come to work in that industry? Hence it will be compulsory to revise the wages every 5 years. When they have to revise the wages? Every 5 years they have to revise their wages. Okay, maximum 5 years. They can even revise in 1 or 2 years, no problem. Now what is the composition of committee? I told you, appropriate government appoints a committee. That committee is called as an advisory board. Advisory board can also make the subcommittees. So what is the constitution of this advisory committee? There will be representations from employer side and employee side. Okay, so from employer side and employee side, equal number of representatives shall be there. Along with that, 1/3 will be the person who are neutral. That means independent person should be 1/3. And one of the independent person shall also be the chairman of the appropriate government. I hope this is very, very clear. Now, whenever any employee works for less than working hours, like for example his working hours is 8 hours per day, he worked for 7 hours, then also it will be deemed that he has worked for entire 8 hours and he will get the full day's salary. But if because of his unwillingness to work, because of his mistake, he is working for lesser number of hours, then definitely salary is going to get deducted. Okay, so he shall not be entitled to wages if it is failure to work because of his unwillingness and it is his mistake, employee's mistake. Now in the next one, when any employee is doing 2 or more classes of work, see, as per different classes of work, different wages are fixed. So any employee is doing manufacturing and packaging, both of them, can he be paid only one salary? No, he has to be paid aggregate of both of them. So he should get minimum of both the wages. Clear with this? Now going to the next, overtime wages. What is overtime? If number of hours per day, it's 8 hours. Okay, number of hours is 8 hours and he has worked for 10 hours. So 2 hours is overtime he has done. So for 2 hours, will he get salary? Yes, he has to get extra wages. How much extra? He's supposed to get minimum twice the salary. Okay, so for overtime, not less than twice the wages he's about to get. So if per hour salary is 100 rupees, for overtime he shall get 200 rupees per hour. Clear with this? Understood? What should be the mode of payment? The mode of payment should always be current currency of the country. Nowadays we can always give in the Paytm or directly crediting in the bank account, by check, currency note, coins, or directly in the bank account by electronic mode. Okay, so fixation of wages happen weekly, fortnightly, etc. So that's it with the Minimum Wages Act. Okay, now we shall start with the next chapter, that is Payment of Wages Act 1936. Again, this is very small chapter. So the earlier act we saw, Minimum Wages Act. In that act we saw that for different schedule employments, for different classes of work, minimum wages are fixed. Okay, now whatever minimum wages are fixed, those has to be paid on time. So when they have to be paid, it is given in the Payment of Wages Act 1936. So all the workers who are working in any factory, establishment, industries provided under this act, they shall get the remuneration on time. What shall be their wage period? How much is the payment limit of their remuneration? Can employer do deduction in their wages? All these things we are going to see. So let's begin with the very first provision under this act, which says that employer can fix the wage period. Wage period can be daily, it can be weekly, it can be fortnightly, or it can be monthly. But in any case, the wage period cannot exceed 1 month. This I have discussed in the previous chapter as well. Your wage period cannot be exceeding 1 month. Okay. Yes. After that, right now, Government of India, that is your appropriate government, has increased the ceiling of monthly wages. They say that different categories of people working in the industry, they should get minimum of 24,000 per month. This was effective from 29th of August 2017. Because inflation is increasing, so that's why it's very much important to increase the ceiling. So please remember, right now the ceiling limit as per Payment of Wages Act is 24,000. Now it will be whose responsibility to pay the wages? It will be responsibility of an employer to pay the wages. Now suppose any of the establishment is controlled by a central government or the state government, and they have employed a supervisor, so it will be duty of that supervisor to pay the wages. If not appointed, then it will be duty of head of the department of central government or state government to pay the wages. When any of the industry is covered or controlled by a local authority should have appointed the supervisor, then it will be duty of supervisor to pay the wages. But if supervisor is not appointed, in that case the chief executive officer of that local body shall be responsible to pay the wages. Okay, so in the private sector enterprises which are controlled privately, the person who is having ultimate control shall be called as an employer, and it will be his duty to pay the wages. So apart from these provisions, when the wages are to be paid, that is very important. In case of your railways, factories, other establishment, industry, where less than 1,000 workers are employed, okay, where less than 1,000 workers are employed, they have to be paid on or before 7th of the next month. Like for example, I have worked for month of April. My wages I should get on or before 7th May. Understood? So on or before expiry of 7th day of next month, workers should get in case less than 1,000 employees are employed. Now in case in any factory, establishment, railways where more than 1,000, that means 1,000 or more employees are employed, they should be paid on or before 10th of next month. So they should be paid before 10th of next month. In case of termination of office, that means your employee left the job due to resignation, removal, it can be any consequence, any result. So when his office is terminated, his pending salary should be cleared on or before expiry of second working day. So when he left his office on or expiry of second working day, his all dues shall be cleared. Guys, in this chapter, these provisions are very, very important. Please make a note of it. Okay. Now, apart from that, we have to learn certain deductions. Employer can deduct wages for the following reasons only. Okay, Employer can make deduction for the following reasons only and not for any other reason. This question is asked in your exams. Okay, so in which circumstances employer can make deduction from the employee's salary? For fine. Employee has caused damage or loss to the employer or any misconduct he has done, so fine can be levied, that can be deducted. Suppose employer is providing any of the amenities or services, facilities. So for providing that amenities, he can deduct the salary. Suppose employer has given some advances to the employee, like advance 3 months salary is given. Then also those 3 months salary can be deducted in the wages. By mistake, employer has paid more to the employee. That overpayment can also be deducted. Employer has given loan to the employee, so the installment as a loan, it can be deducted. Suppose employer has given some house building or other purpose, this can also be deducted. Income tax are always deducted, like TDS, yes, we always deduct the income tax. We have seen the provident fund, the contributions are to be made and that contribution is deducted from the employee's salary. Or your employee is member of any of the cooperative society or the trade union. So for giving that membership fees, that contribution can be deducted. The next one talks about contribution for the fund of the trade union. If employer has suffered some losses due to employee, then he can recover the losses by doing the deduction. He can recover the losses by doing the deduction. I hope this was very clear to all of you. And whenever he is making any deduction, it will be his duty to maintain the register. Okay, in the register he shall make various entries like how much salary is paid to any particular employee and how much deduction was made from that salary and the reason why deduction was made. These three things becomes very important because when any case is filed, any inspection inquiry comes, the register would be a proof of all the track. I hope this is very clear, guys. With this, we complete our payment of wages. Again, a very small act we are going to learn. That is Payment of Bonus Act 1965. See students, these four acts basically, that is Minimum Wages Act, Payment of Wages Act, Bonus Act, and one more act is there which is not there in your syllabus, that is Equal Remuneration Act. These four acts are subsumed in one particular code. The name of that code is Code of Wages Act 2019. Okay, still it is not made applicable. That's why we are learning this act differently. But they are trying to combine these different labor laws into one particular heading so that we read it together instead of reading so many labor laws. Okay, but right now in your syllabus we have it differently. So payment of bonus, what is the meaning of the bonus? See, our shareholders of the company, they receive their bonus. Those bonus is very different. This is bonus of an employees who are working in organization. Salary they are getting, that is great. But whenever company does profit, it will be duty of a company to share some part of a profit with employees also. Or when employees have done wonderful work, in that case also company should give some motivation to the employee. So your appropriate government has mandated certain industry, that is scheduled industries, to give bonus compulsorily to all of its workers. Okay, so let's see provisions of the act. Is it applicable in all the industry? Yes, all the scheduled industries where 20 or more workers are working. Where 20 or more workers are employed, the act becomes applicable. On what basis the bonus will be given? Bonus will be given on the basis of profits made by company and the productivity. Okay, how much productivity your employees has given. Are all employees eligible under this act? The answer is no. See, basically eligibility is divided into two parts. The first is employee. All employees are not covered under this act, but employees receiving salary not exceeding 21,000 are only covered. Okay, others are not covered. And as far as calculation purpose is concerned, okay, we calculate bonus as if employee is receiving 7,000 per month. So bonus is calculated on 7,000 per month. Okay, now what is the meaning of this? See, suppose Mr. A monthly salary is 15,000 rupees. Even though his salary is 15,000 rupees, bonus will be calculated as if he is receiving 7,000 per month. Clear with this? Understood? Yes. Now, first, before going to the time limit, we will see how much bonus is to be given. So, we are going to see ceiling of the bonus. Minimum bonus which every employer should pay wherever this act becomes applicable is 8.33% of wages of employee. How much? 8.33% of wages of employee. Okay, this is a minimum bonus, or in case he has more profit, more productivity, the maximum bonus which he can pay along with the productivity bonus and all is not exceeding 20% of the wages. So minimum 8.33 and maximum 20%. Now, in your industry, you may have culture that you give puja bonus, or your boss got married or some other achievement, so he is happy and he is giving bonus. So can that bonus which is already given be clubbed with this mandatory bonus? The answer is yes. So if puja bonus is given 5% to all employees, then the mandatory bonus will be given only 3.33% because already 5% is given. I hope this is very clear. Coming to the time limit, when till what time bonus has to be paid? When there is a dispute among the employer-employee regarding the amount of bonus. In that case, within 1 month of settlement of dispute or whenever judgment award is given, within 1 month of that, employer has to pay the bonus. In normal circumstances where there is no dispute, all the employees should be paid before or within 8 months of closure of your financial year. That means our financial year closes by 31st March. So within 8 months of that, so April, May, June, July, August, September, October, November. So on or before 30th November, they should be paid bonus. Clear? Now, some additional compliances as far as your disqualification for bonus. Section 29. All employees are eligible for bonus, but if they do some act which is against the property of company or which is not good for the company, they will become disqualified for the bonus. So when will employees become disqualified for the bonus? Employee shall be disqualified if he is dismissed from the service. Employer has dismissed him from the services because he has done fraud, or he has done any of the riotous or violent behavior in an organization. He is making fight, beating other employees. So he is doing violent behavior, or he has done theft or misappropriation or trying to destroy the property of organization, or he is convicted for the sexual harassment. So only in these 4 cases, if his services are dismissed, then he shall be disqualified from getting bonus. Okay, please remember all these 4 correctly. Don't write any of your own points because in law we have to be very specific. Okay guys, so this is all for bonus act, only this much you have to remember. See guys, chapter 17, even though it looks very lengthy, if you make a flowchart of different acts, only few things you have to remember, right? Then this chapter again will become very easy for you. Now let's start with the next act, that is Trade Union Act 1926. If you look at the year, it's a pre-independence act, right, 1926, but it is still valid, okay, because of one of the provision in the constitution. Certain pre-constitution, pre-independence laws are also valid. Now coming to the point, what is a trade union? Trade union is nothing but it's an association of employees and employers, okay, and sometime even employers may be the party to it, but basically it's the association of employees. Now why association employees are made? In order to do collective bargaining. We have learned the concept of collective bargaining in your Industrial Dispute Act, right? So in order to do collective bargaining, there will be association of person. Like there is a factory and 500 employees are working. Every employee has different problems. So every time they cannot go through the boss. Boss is not so easily reachable. Hence, they will make association called as a trade union, and there will be the head of the trade union or the leader of the trade union. This leader shall go to the employer and protect the right of the employees. So this is how it happens. So trade union helps to do collective bargaining. Any of the employees are not happy with any of the management decision, they can fight together. This is the idea of trade union. Now this trade union is legalized. Okay, how it can be legalized? It's not compulsory that trade union, if you want to form, you have to register it. If you don't want to legalize it, you can have unregistered trade union. But when you want to legalize it, when you want to fight case in court of law, you have to register your trade union. So trade union is legalized if it is registered. If we register the trade union, then only we can legalize it. Under which act it has to be registered? It has to be registered under this act. Okay, so when it becomes registered, it gets basically a legal character. What does it get? Legal character. Also, it can hold property in its own name. Okay, so it has a separate legal entity. So it can hold property in its own name. Also, it can sue and be sued in its own name. It can sue and be sued in its own name. So these are the advantages of getting registered trade union. Now going to the next, how to register a trade union. How to register a trade union. How do we register it? We have to follow certain steps if we want to register trade union. First of all, we have to establish trade union. We have to establish trade union. First, let's go. Who is our nodal officer? Before going there, let us see where we have to register or who is a nodal officer. Our nodal officer under this act is Registrar of Trade Union. Okay, Registrar of Trade Union. So we have to register with the Registrar of Trade Union in order to get legalized. So what we have to do? First of all, we will establish the trade union. After establishing, it needs to be registered, right? It needs to be registered. Can you operate trade union without registration? Yes, you can operate, but it's not legal character, right? So where it needs to be registered? It's Registrar of Trade Union. I am writing it to you. Please don't write shortcuts in your exams. Okay. So first we establish the trade union. Then we want to register now. Now there are certain requirements for the registration. requirements for the registration. Requirement is as to minimum number of members. Okay, so we require minimum 7 workers for the trade union. How many we require? 7 for the trade union, or 100 workers, or 10% of total workers. 100 workers or 10% of total workers, whichever is less. So it is 7 workers or 100 workers or total of 10% workers. See how you have to see. I'll give you the example of this. Okay, see, if in any industry only 5 workers are working, in any factory or industry only 5 workers are working, can they form the trade union? Can they say that 10% of total workers means 10% of 5 workers, can they do and form trade union? No, because in the first line they have said that minimum 7 workers are required. So in this case they cannot form trade union. Where 50 workers are working, then we have to see the second one, that is 100 or 10% of this 50, that is 5, whichever is less. So we will take 5 into consideration. I hope this is very clear. Okay, so what is the provision? Minimum 7 workers, minimum 7 workers or 100 workers or 10% of the total workers. So at least 10% of workers should be with you, then only you can register your trade union. The moral is that. I hope this is very clear. So this was the requirement. Please remember this. So this was a third point we did. Now we are going to the fourth one. We have to make application for the registration. What do we have to make? Application for the registration. Okay, how are we going to make application? We have to apply, which form they have not given, but we have to provide them with the documents along with the application, that is copy of trade union rules. Like company has its memorandum articles, trade union has to have its rules. Okay, so copy of trade union rules. Then statement we require. With statement we have to give statement as to details of workmen. So name, address of all the workmen who are working in an organization. Then we need to give details or proof of registered office of trade union where you are going to operate your trade union. Okay, that is what is a communication address. Apart from that, if your trade union is existing one, that means you formed trade union 3 years back and you are registering now, even that is valid. So your trade union is existing. In that case we need to give audited balance sheet and P&L. What you need to give? Audited balance sheet, P&L, or annual return. Clear with this? These are the documents which we need to file when we are making application. Where are we going application? Registrar of Trade Union. Okay. Now fifth, once we give application, if Registrar of Trade Union is satisfied with our application, then it shall issue us a certificate of registration. What shall it issue? It shall issue certificate of registration. Once we receive the certificate, whatever date is written, that is the date on which we have registered our trade union, and this certificate will be your conclusive evidence. Okay, you don't need any other evidence for this. Understood? So this certificate of registration act as a conclusive evidence. Okay, yes. So after that, the next point, this registration which is granted to us, can registrar of trade union cancel Yes, they may also cancel the registration. So the next point, can registration of trade union be cancelled? The answer is yes, it can be cancelled. Now on what point it can be cancelled, we are going to see that. If your registrar of trade union, if your registrar of trade union is of opinion that, okay, registration is obtained by fraud. How we have obtained the registration? Fraud. So when we have obtained registration by fraud, it may take action against us and cancel the application. That means our registration, we have already been registered, right? Or registration is obtained by misrepresentation. How we have obtained? By misrepresentation. Or registration, or we have done contravention of any condition, contravention of any condition of our registrar. So registrar had given us guidelines or the condition, we did not follow that, it may take action and cancel our registration. Or our minimum number of members went below the limit. Minimum number of members went below the limit. In this case also they may take action and cancel our registration. Okay, yes. So I hope this is very clear. Please remember, this is very important from your case laws point of view. When can registrar cancel your registration? Now the next point, even trade union has an yearly compliance. So trade union need to do compliance and filing with the registrar of trade union. Over here when I say registrar, I don't mean ROC, but I mean registrar of trade union. So there are certain returns to be filed by, or we can write before, registrar of trade union. Now who will file? Obviously our trade union will file, who has been registered. So in company we follow our financial year as 1st April to 31st March. But over here trade union returns are to be filed as per the calendar year. So our year will be starting for trade union for 1st of January to 31st of December. Are we going to make the balance sheet of a company's profit and loss? No, it will be only and only restricted to the accounts of the trade union. Please remember this. Okay, so first we need to file balance sheet and P&L as on 31st of December every year. Every year we need to file balance sheet P&L as on 31st December every year. Also along with that we have to file a general statement, okay, of office bearers. Which office bearers? Am I talking about board of directors? No, it is office bearers of your trade union. Even this will be as on 31st of December every year. Okay. Also whenever your office bearer change, your chairman, vice chairman of your trade union change, even then you have to intimate to your registrar. Okay. So in case of change in the office bearers, we need to intimate registrar of trade union. When we have to intimate, please remember, within 15 days of change we need to intimate. Okay, I'll highlight this for you, it will be very easy. Within 15 days of change we have to intimate. Clear with this? Understood? Now also it will be responsibility or duty of your registered trade union that it has to maintain proper books and records. Anytime registrar may come to the registered office and inspect the documents. Okay, so it will be duty of trade union to keep all the books and records at the registered office. Okay, so at the registered office they have to maintain books of accounts and other registers. Okay, so that's it guys, we have completed this chapter. Whatever notes I have given, please refer to those notes, very important. Okay, you can take the screenshots if you need. Now let's start with our question answer part. I understand chapter 17 was little lengthy, but it is very scoring also because weightage is more. So don't leave your chapter number 17. Now looking at question and answer, you will get confidence that how questions are asked. And if you have done with your syllabus properly, 100% chances are there that you will clear. So let's begin. Srivastav is owner of Unit Manufacturing BD in Jabalpur. 22 people are employed in unit. Of this 22, one is graduate for supervising the work, another apprentice learning work. Remaining 20 are employed not on time wage system but on piece work system. Is unit a factory within meaning of this act? You have to write definition of factory, simple, 10 or more working with the aid of power, 20 or more working without the aid of power, where manufacturing is going on, and the exclusions, right? This all are the exclusions. So for computing, we have to count all the workers working in all the relays. So over here, when we count together, there are 22. Hence, it is a factory. Simple? Yes. Next. JIGL Limited is a public sector undertaking in business of cement manufacturing for education to children of employees in near villages through a trust. Company also runs a primary school with premise of society of a company. In the premises there is a school also. So some person of village are differently abled, physically challenged. Right of Person with Disabilities Act speaks about provision relating to education of children with disabilities as well as duties of educational institution. Explain duties of educational institution. Again the straightforward question. This we have already done and we were learning this chapter. I had told you that this question was asked. I hope you remember. Then, state government has decided to sell the loss-making undertaking in sector of water supply. Workers employed in sector announced strike, okay, to protest the said decision. In such situation, what are circumstances under which said strike shall be treated as a breach of contract? Whenever any public utility services, when they want to go on strike, I had told you they have to comply with certain conditions. Notice is required. So if they don't give notice, okay, then it would be a breach of contract. This is what you have to write. Next, state the circumstances under which employee is not liable for compensation under Employees Compensation Act. Again, a straightforward question it is. Then, Sarovan is carrying out a building contract work for industrial and commercial customers. He engages 25 workers on regular basis. Wants to know about applicability of Contract Labor Act to him and licensing requirement. Also brief him details regarding registers to be maintained. Basically, register is not for you, not in your syllabus, so you can disregard this question, no problem. Okay, so what you have to say, whether he is liable to take the license, the answer is yes. Any person who is employing contract labor of 20 or more people compulsory to take the license, right? Then a factory has 100 male employee and 50 female. Factory manager is keen to know what are the facilities required to be provided. So first aid box. One first aid in 150 workers, right? Second, canteen. 250 or more workers are there. We require canteen facility. Crèche. 30 or more women are there. Crèches. Understood? So you have to write all this. Now, Sukrit is running a small fabrication unit with 5 workers. He is planning for expansion and it may require addition of 10 to 15 employees. He is planning to register his business under employee state insurance and extend the benefit to employees. Okay, so this is what is asked to you. Again, a straightforward question it is. So that's it guys. I hope you have understood chapter 17 and what kind of questions are asked. Purely straightforward questions. Now we are at chapter number 18. Chapter number 18 is the last chapter in your part B. Okay. And this is very easy chapter as compared to chapter number 17 and 13 because 17 and 13 are huge chapters. But yes, weightage is also that much. So weightage for this chapter number 18 is around 5 marks. Okay. In this particular chapter, we are going to learn about environmental laws. This environmental laws we will not be learning in detail, but only those provisions which relates to a startup. So when any entrepreneur wants to start any of the industry, definitely it needs to comply with the environmental laws. And whatever provisions are applicable to them, the basic provision, only that much we are going to learn. So in short, we are not doing deep study of this environmental laws. There are total 5 sub-chapters in this. So we are going to learn first Water Pollution Act, then we have Air Pollution Act, then we have Environmental Protection Act, the fourth one is a Public Liability Insurance Act, and the last one is a National Green Tribunal. Out of this 5, ICSI favorite part is environmental laws and NGT. Most of the times we have seen that they ask question from these. This does not mean that other parts are to be left out. No. They can ask you anything, but yes, weightage is not more than 5 marks. So without wasting any time, I will show you something. We might have seen this many a times. Okay, this is the latest recent issue as well. But this we are learning from standard 2, standard 3, something called as a pollution, right? So environmental pollution, there are various kinds of pollution. In the first picture you have seen the air pollution. So poisonous gas are emitted out of the factory. Those poisonous gas get mixed into our fresh air or the atmosphere and it causes various diseases and problems to us. The second one you are saying the water. Okay, outlets from factories and all. Okay, they discharge the dangerous water or I can say polluted water which is a result of a production. So that polluted water get mixed with the river, ponds, lakes which are sources of our drinking water. So that pollutes our drinking water, right? So even that is a problem. In the third one we are looking at the soil pollution. We have deforestation issues, so many issues because of cutting down of trees. The next pollution is the light pollution and the last one is the noise pollution. So all these kinds of pollution is becoming major problems to us. So Government of India focuses on making this repair. I know 100% it's not sure, it's not possible to repair this, but yes, we can prevent the pollution by using the alternatives. Like we have various renewable, non-renewable resources. If we can use most of the renewable resources, then the consumption of non-renewables can be decreased, and this is how we can save it for our future generations. So when this part is going to get covered under the Environmental Protection Act. So without wasting any time, let's start first chapter, that is Water Pollution Act. So what is a Water Pollution Act? As I told you guys, here we are only going to learn the provisions relating to the startup. We are not going to learn anything in detail. Okay, so the very first chapter under this comes is Water Prevention and Control of Pollution Act 1974. Please remember this name very correctly. Okay, what is the name of this chapter? Water Prevention. Okay, we have to prevent the water pollution and control it. Act 1974. So under this chapter, two important things to be highlighted. Our Government of India aims to reduce the water pollution. Because of that, it has made one industry called as Ministry of Environment and Pollution. What is the name of that ministry? It's a Ministry of Environment and Forest. I hope you remember this ministry because we have learned this in chapter number 9 as well. Okay, because this ministry had given a list of those industries, yes, which can do only and only compliances on the self-certification basis, no need to do the audit on that. So this Ministry of Environment and Forest, it takes care about all of the pollution. So Government of India has established this ministry in order to take care of the pollution. Now this ministry, MOEF, it further makes various committees, boards to take care of the pollution. Like we have two boards, one at the central level called as the Central Pollution Control Board and another at a state level called as State Pollution Control Board. Okay, so Central Pollution Control Board and a State Pollution Control Board. These are the two boards which will take care of Water Pollution Act as well as the Air Pollution Act. So we are going to learn about this board in this Water Pollution Act. Now let's start with the Water Pollution Act. Before going to the act, let's learn the important definition under this act. The very first definition talks about what is a pollution. Okay, over here we are talking about the water pollution, hence the definition we are going to learn about is water pollution. So what is a water pollution? I have told you in the general language, but now we are going to see in the definition language. So it is a pollution, which means there is a contamination of water. Okay, contamination means making a good thing into a bad, that is safe drinking water into polluted water, that is contamination of water by alteration of its properties. Okay, which properties? Physical properties, chemical or biological properties, or there is discharge of any sewage. In water pollution always there is a discharge, remember, and in air pollution there is emission. So please remember these two words very specifically. For water pollution it's discharge and for air pollution it is emittents. Okay, so discharge of any sewage or trade effluents. Why do we call it as a trade effluents? Because it is done in the manufacturing process. That's why trade effluents, or any other substance, it can be liquid, solid or gaseous substance, which creates a nuisance. Okay, it is creating a problem or render the water harmful for the public health. Also, to domestic, commercial, industrial, agricultural, other legitimate uses, or life of plant, animals and aquatic organization. So this is a definition of a water pollution. Important things to remember: it's a contamination by changing the properties or discharge of the water which is polluted, which has any of the gaseous substance or the contaminated substance, which leads to water pollution and harmful to everybody's life. So this is how you have to learn the definition. Now the second definition is a trade effluent. What is a trade effluent? Trade effluent can be anything. It can be any substance which is in solid, liquid, gaseous form, okay, which is discharged from any of the premises which is carrying on industrial activity, production, process, treatment, anything. But it is done in the industry premises, hence it is a trade effluent. So over here the domestic sewages are not included. Domestic sewage is not a trade effluent. If you wash your utensils in your home, that's a domestic sewage, hence not covered. Okay. After that, sewage effluent. Sewage means the outlets which we have in the industry, in the houses, etc. So it's a effluent from any sewage system or sewage disposal. It also includes sewage from the open drains. So these are the three important definitions in the Water Pollution Act. Now, as I told you, there are two boards under water pollution and air pollution. There are two boards, one at central level, another one at the state level. So at the central level, we have a board called as Central Pollution Control Board. Okay, so in the short form, we can write it like this: Central Pollution Control Board. Short notes only and only for making notes, not in the exams. In exams, you are not going to write any short notes because we know the shortcuts. Your moderator might not know about this. Understood? So what is CPCB? It's Central Pollution Control Board. Now, we are going to learn the constitution of this board. This board shall consist of a full-time chairman, okay, members from the government, from industry and agriculture. Apart from there, we require a full-time member secretary. What do we require? We require a full-time member secretary. This Central Pollution Control Board can also form more committees in order to help them out. Okay, so please remember. Now we are going to see what are functions of this committee. This committee is at the central level, hence going to see about various states. Okay, so the first one, it promotes cleanliness of streams and wells. So cleanliness of streams and wells will be promoted by your CPCB. It may also advise your central government to prevent and control the water pollution. So if central government has any of the issues relating to any of the water pollution, it may consult the CPCB in that. Also CPCB, if it finds any dangerous thing happening, that means more of pollution is done in any of the river, it may immediately contact the central government for that. After that, it also coordinates activities with the state board. It's essential because if entire India wants to prevent water pollution, it's also important that state board also coordinate. So central board and state board, if they coordinate with each other, the pollution control will be more and better. After that, if any of the state board requires any of the technical assistance or guidance, then CPCB shall provide for that. Okay, it also organizes and plans training for the person. Okay, so any person who is an industrialist or any person who is working in the industry, it may give them training how to prevent and control the water pollution so that least pollution is happening. After that, for creating awareness among the people as far as industry is concerned, it may also organize some programs wherein the importance of drinking water shall be taught, and also how to prevent and control the water pollution in the industries. Then they have to collect the water pollution information, they have to compile the information, and they have to publish that. This data they need to remember, collect, compile and publish, maintain the data, so they have a track record how much was the pollution in the previous year and how much it is now. After that, for any stream or any well wherein the pollution is there, it will lay down standard how much is the maximum pollution which stream or well can have. If the maximum limit is reached, nobody can discharge the dangerous water into that stream or a well. After that, central government may give them other functions. These are the functions of the central board. Now we are going to the state board. As I told you earlier, there is one more board called as State Pollution Control Board. This is at the state level. So every state in India shall be having this board who will be looking after the water pollution and the air pollution. So under Water Pollution Act, what are the functions of the State Pollution Control Board? Before looking into the functions, we are going to see the constitution of this board. So this board is established or constituted by a state government. The earlier board was constituted by the central government. So it shall have full-time or a part-time chairman. Okay, so it shall have a full-time or a part-time chairman who has a special knowledge in environmental protection. Also, they require a full-time member secretary. Okay. Now, what are the functions of this state board? First of all, it will have a program for prevention and control of the water pollution. When and where asked upon, it shall also advise the state government regarding the water pollution. It is also encourage research and investigations. So wherever it finds that in particular water or any other river, more pollution is there, it may do research and also investigation into it. Okay, because it has to look after its particular state only and not the other state. Then it is important for them to collect and furnish the informations. So whatever pollution is there in that state, they have to intimate them and also tell. Where they have to tell, they have to report it to the state government, and they also have to tell that what are the measures taken for that pollution. After that, sometimes they may collaborate with the central board and give trainings to the people who are working in the industry so as to control and prevent the water pollution. They may also inspect any of the sewages. They may also start the treatment of the sewages and review the plants. Okay. So wherever they think fit, they may inspect the sewage and also review the plants. And if they feel over here they require treatment of water, they may do the treatment of the water as well. They may also lay down the standards, how much is the maximum effluents allowed by any of the industry. They may also evolve upon treatment of sewages if at all to be done at the economical cost so that all the industrialists can afford that. It may evolve the methods for disposal of sewages and the trade effluents. They may make an order to prevent, control or abate the effluents. Okay, they may also plan to construct the sewage system over there. If sewage system is found not correct, they may also repair that. Okay, along with that, it also advises state government which industry should be located in which area. So locational restrictions, guidance will be given by your state board as well. Also, they shall perform other functions as given by the state government. Also, their function is to establish the laboratories. Now, which kind of laboratories they are talking about? They are talking about the environmental laboratories. Okay. Now, why laboratories? If we want to test the human blood, we send it to the pathologist laboratory. So, that is a human laboratory. So, for checking how much pollution is there in water, air, their samples are also collected. So, samples from river, air, seas, the samples are collected and sent to this laboratory, that is environmental laboratory, wherein the environmental analyst is there. Like for humans, we have pathologist. For environment, we have an environmental analyst. That analyst shall give a report that how much percentage of pollution is present in this water. So this is a reason even laboratories are important in the environment sector. I hope you understood about the state board and the central board. Now, I hope you have understood what is a state board and a central board. Now the state board and the central board, basically the state board, it shall in consultation of a state government. Whenever any of the state government feels that in any particular area more of water pollution is done, so it shall consult the state board, that is state pollution control board, and declare that particular area as a water pollution area. Also, industries which are located in that particular area, on that various conditions and restrictions shall be imposed. Like they have to insert or they have to establish the water pollution control system, that is a filters. Also, they have to use only the alternatives. So, these are the condition which can be imposed. So, your state government, after consulting the state board, if it is of opinion that a particular area or areas may be declared as a water pollution prevention and control area. So it can be marked as water pollution prevention and control areas. It may not be on entire state, but it can be any particular area. They can put a boundary on that, and this is how they will declare this area as a water pollution prevention and control of water pollution. So how do they mark that particular area? They can mark that area by giving reference to a map, or they can also refer it by putting a line or a watershed. Watershed means the boundary of river or something like that. It's a watershed. So this area which they have declared, they may alter that any point of time. If they want to add more area into it, they can add it any point of time, and whenever they feel that this area now pollution is controlled enough, so they may open up that area and delete the name as water pollution control area. I hope you understood the provisions relating to marking of the areas. Now when such areas are marked, as told you, various restrictions are there. So when any person in that area, they want to build an industry or establish industry, or the existing industries which are there, they want to open a new outlets. So first they need to take a license from a state board. We already have discussed what are kind of the licenses required. We have two. One is consent to operate, another one is consent to establish. So consent to establish we have to take first and consent to operate second. So in this water pollution area, if anybody wants to set up an industry or start a new outlet, alter the existing outlet, they need to take consent from the state board. For that they need to apply to the state board. Okay, so let's read. So no person without previous consent of the state board establish a new industry, operation, process which is likely to discharge sewage into stream or a well, or any of the person who is existing, that is any industry which is existing, they cannot bring into use a new one or altered outlet for discharge of the sewage. Then if they want to make use of new discharge of sewage, they have to first take the consent of the state board. I hope this is clear. Now, as I told you, application has to be made to the state board along with the given documents, whatever is required. After that, once application reaches the state board, if state board is satisfied, I will explain you over here. Once application is sent to the state board, if state board is satisfied with the application, in that case it shall give approval, but along with the approval some conditions shall be imposed on it. Okay, so once these conditions have been imposed, this condition needs to be complied with. If any of the industry who has got approval, they do not comply with this condition, then what will happen? It will be revocation of the consent. Okay, so whatever conditions they have put in, they will keep a record book for that and they will record all the conditions what they have put in. Okay, but if the state board is not satisfied, if state board is not satisfied, so they may reject your application, but whenever rejection is given, it should be backed with the reason. So reasons are mandatory and reasons have to be in writing also. Clear with this? Understood? And this application which is given to the state board, they have to dispose the application within 4 months. Within how many months they have to dispose the application? Within 4 months. So within 4 months, state board has to tell whether they have accepted your application or they have rejected the application. If they do not tell you anything, it will be assumed that the application has been accepted. So it's a time bound process. They have to make it within 4 months. I hope this is very clear. Now, suppose if any of the industry, they do not obtain the consent, okay, then what will happen? Strict penalties will be liable to them. Okay, so they have to take or dispose the particular application within 4 months. Please remember this. Now, there is a concept of power of taking samples. Now, what is power of taking samples? Suppose any time state board or your state government feels that in this particular industry more of water pollution is there, that discharging more effluents into any sea or lake or river, they may give an order to take sample from your factory and give it for testing. So this is power to take the samples. Very simple procedure it is. First of all, a notice will be served on an occupier of factory that the particular authority shall be coming to take the samples. Okay, so first of all, a notice shall be served. Notice shall be served on person in charge of the place. Samples which are taken, the samples shall be taken in presence of that person only, that is the occupier. If occupier is absent, willingly absent, he knows that person is going to turn, then the samples can be taken without him also. Okay, sample has to be taken in a sealed container and this container shall be signed by both the parties, the authority along with the occupier. Okay, then samples which are collected will be sent to the approved laboratory, that is environmental laboratory. Analyst will be present over there. Analyst shall send report to the state board along with the factory also. Okay, I hope you understood this. Yes, so report of analysis shall be signed by approved analyst. Then copy of report should be given to person in charge of the premises. Now, there are certain powers of your state board as well. See, state board is a board for taking care of pollution. So state board cannot take law into their own hands. So when any of the industry is not complying with any condition imposed by the state board, and state board thinks that there may be a danger of pollution from this industry, they can go to the court of law. Okay, so any point of time, any of the state board want to restrain any of the pollutants into streams or wells, they can make application to the court. Which court is this? Over here we have criminal court. So in the criminal law, you will be learning this in your jurisprudence. In the criminal law, we have various categories of courts. So where we have to go under environmental pollution, state board can go to the judicial magistrate of the first class. Okay, so they can make application to the judicial magistrate of the first class. Now why application is there? To apprehend the discharge into some stream or well. They want to stop them from discharging into stream or well. So when application is sent to this judicial magistrate of first class, if court find it's correct, it may restrain any person from causing this pollution. So for restraining, he himself may be taking the implementation into his hands, but suppose implementation is not possible with him, he may also authorize the board, that is a state board, to remove all those discharges from the industry. Okay, so implementation is given to the state board, and whatever cost state board incurs on behalf of the factory, everything may be recovered from the factory. Okay, so this is how it goes, and this recovery can be done in the form of arrears of the land revenue. Now any point of time, your state board has various power. It can give direction. Which direction? To perform any of the acts, and this direction can be given in writing, and they have to comply with the orders of the state board. So in case the directions are not complied with, what all things state board can do? State board can order closure or prohibition or regulation of any of the industry, operation or process. It may also order stoppage of electricity or regulation of water or any other service or any other order. So for implementing its direction, if nobody is listening to them, they can order any of these things. So I hope you have understood this. This was all for your Water Pollution Act. Now we are going to start with the next act, that is Air Prevention and Control of Pollution Act 1981. The earlier act was 1974, and now this act is 1981. So please remember the act name. Also this is a Air Pollution Act. So let's begin with the act. Now what is a air pollution? As discussed in the introduction video, that whenever any production process is going on, polluted water is discharged. Along with the polluted water from the machineries, okay, gases are also emitted. These gases are polluted gases. So industry will have huge chimneys, okay, in order that the gases should not circulate. They have a system to let out that gas. But when such poisonous gases are let out in the atmosphere, it also causes the environmental pollution, also called as a air pollution. Hence, to prevent and control that, there are certain measures taken by the government of India. Now, as discussed in the Water Pollution Act, we have two boards, okay, one at the central level, another one at the state level. At central level, we have Central Pollution Control Board, and state level, State Pollution Control Board. This board shall prevent and control the water pollution and the air pollution. So what is the air pollution? The main aim of this act is to prevent, control and abate the air pollution. Okay, also they have boards, one at central level, another one at the state level, for preventing, controlling and abating the air pollution. Okay, now there are various problems associated with the air pollution. One problem is the quality of air we are inhaling. It's a most dangerous quality. Because of that, so many diseases have come up, especially the asthma. Okay, asthma, then coughing, sneezing, this all happens because of this air. Now, air pollution, they want to prohibit the use of polluting fuels. So there will be certain area which will be marked as a air pollution control area. In that area, they will not allow to use a polluting fuels. So they have to use a alternatives compulsorily. Okay, they also have to lay down the regulating appliances. So there will be a pollution control equipment. It should be on every time they are doing the production. Okay, so these all conditions will be laid down the State Pollution Control Board in the consultation with the state government. Now, definitions. Like we saw the definition of water, we are going to see the definition of the air pollution. So what is a air pollutant? Air pollutant can be any solid or liquid or the gaseous substance. It also includes the noise. Please remember, it also includes the noise which is present in the atmosphere in such a concentration which is going to injury to the human health. Okay, so please remember this. It is in such a concentration in an atmosphere or an environment which is going to harm the health of human beings, also other living creatures, and also the total environment. This is a air pollutant. Now what is a air pollution? Air pollution means some air pollutant is present in the atmosphere, that will be called as a air pollution. Then we have a control equipment. In order to control the air pollution, it will be compulsory to establish or install a control equipment in every industry. So it means any apparatus or device or equipment or system to control the quality and manner of the emission. Okay, so air pollutant will be controlled in this. So it includes any of the device which secures the efficient operation of industrial plant. Now what is a emission? I told you in water pollution there is always discharge of water pollution. In air pollution we have a emission because it's in a gaseous state. So emission means any solid, liquid, gaseous substance coming out from chimney, duct, flue or any other outlet will be called as an emission. Now going to the Central Pollution Control Board. So this we have already learnt. So in Central Pollution Control Board, what are the functions under air pollution we are going to learn? Functions under water pollution we have already learnt. So under Central Pollution Control Board, the functions are to advise the central government about the pollution control, to plan for the nationwide programs relating to the air pollution, to coordinate activities with the state board, to provide for the technical assistance whenever state board shall require that, to do functions of the state board as and when required. Also they provide the training like they provided in the water pollution, to lay down the comprehensive program for prevention, control and abatement of the air pollution. Also to collect the statistical data, because we know state board and the central board has to collect, compile and publish the data for the future reference. Then lay down the air quality standard, what should be the standard of the air. Okay. Then collect and disseminate the information. Also set up the laboratories. These are the main functions of the Central Pollution Control Board under the Air Pollution Act. Now there is a State Pollution Control Board which is under the state government or for the respective states. So what are the functions of this state board? Functions of the state board shall be lay down the programs for prevention, control, abatement of the air pollution. Then they also advise to the state government relating any of the matters of the air pollution. Also they collect, compile and publish the information relating to the air pollution. They also collaborate with the central board to do various programs in the state level and also at the central level in order to educate the people relating to importance of the pure air. Also they inspect any of the control equipments whatever industry have installed, or they can also inspect the industrial plant or the manufacturing process. Also they inspect the air pollution control areas when and where required. Also they lay down the standards how much air pollutants can be emitted by any of the industry or factory in the atmosphere at large. Also they advise the state government about the location, in which location which industry should be set up, about the red category industry, blue category industry, okay, as we have learnt. Then they also establish the laboratories. These are the various functions of the State Pollution Control Board. Now going ahead, like we have seen in the water pollution guys, whenever state board thinks that excessive water pollution has happened in any of the river, lake, sea or in that area, they declare that area as a water pollution area. On the same lines, when your state board thinks that more pollution has happened in any of the area, they may declare that area as a air pollution prevention control abatement area. I hope this is very clear. So this will be declared by whom? State government, but in consultation with the state board. They may declare area or areas within the state as air pollution control areas. Okay, and whenever state government thinks that we need to alter this area, we need to add up to this, we need to delete this area, it will be done in consultation with the state government, but power is there only and only with the state government. Along with that, if after consultation with the state board, state government is of opinion that in that area only one particular fuel can be used, okay, that is an approved fuel, they may publish this in the official gazette, and when it is published in the official gazette, within 3 months of that the order is mandatory. So within 3 months all the industries operating in that area, they have to use only and only approved fuel. They cannot use any other fuel without that. Is it clear? Great. Now whenever the area is declared, okay, now there is a rectangular box, say for example, and that area is a air pollution control area, certain restrictions are there on that area. So what are the restrictions? All the industry who are located in that area have to comply. If they don't comply, the consent which state board has given them to operate in that area, that may be revoked. So what are the conditions? First, any person cannot establish industry in air pollution control area without consent of state boards. They have to apply to the state board. This we have already seen in the water pollution also. So application will be given to the state board along with the fees. So person who is already operating in that area, what they have to do? They also have to apply for the permission within 3 months of the new notification. So suppose I will explain you like this. This area is today declared on, say for example, 1st of March as air pollution area. Okay, today it is declared as air pollution, but before this declaration there are already industries who are set up over here, right? So these existing industries have to take consent of board, that is consent to operate from whom? State board. Within how many months? Within 3 months of order. So within 3 months of the declaration, they have to take approval from the state board. And for the new industries, before establishing, they have to apply. Is it clear? Great. Now, after making inquiries, if board feels that the application is fair enough, it may grant you consent. But yes, consent will be backed by conditions. Okay. And if consent is refused, you will get the reason why it is refused. But it will be very important to comply with all the condition in case it is granted. Okay, so consent is always subject to certain condition. Permission or refusal should be given within 4 months. We have already seen this. Now, what are the condition in case the consent is granted? Very important from the exam point of view also, you can remember this. Now, first of all, control equipment has to be set up. Now, you cannot set up any control equipment, but whatever specification is laid down by the state board, only that control equipment should be there. So, control equipment should be of specific specification which is granted by the state board. It should be installed, operated in the premises. If there is an existing industry, then they have to replace if it is not in the specification laid down by the state board. Along with that, equipment should be running good all the time. Also, they should erect a chimney. Chimney should be also as per the state board specifications. Other condition, if it thinks fit, state board may give you that. Okay, I hope this is very clear. Yes. Now, like the Water Pollution Act, in the air pollution also, state board has power to apply to the court in case if it feels that one particular industry is not complying with any condition and there is apprehended danger they may cause a lot of pollution. So, it may apply to the judicial magistrate of first class, and in case of a metropolitan city, metropolitan magistrate of the first class. So, it may apply to the any of one court. Okay, so once application is received by the court, if court finds the application is correct by the state board, then it may restrain order for any other person to discharge or cause emission of air pollutant. If implementation is not possible from his side, he may grant that implementation to whom? The state board, and whatever are the expenses, it shall be collected from the industry as a arrears of land revenue. Please remember. So what are the orders he may give? Direct such person to desist from taking action which is causing emission. It may also authorize the board, if direction is not complied, to implement the direction as given by the court of law. If anyone is not happy with the decision of state board, you apply to the state board for consent to establish or operate, and your consent to establish or operate was rejected by the state board, then we can appeal to the appellate authority within 30 days of that. Okay, we can appeal to the authority within 30 days. Now, appellate authority consists of a single person or a 3 person. It will be appointed by the state government only. So, whenever applications of appeal are received, okay, then appellant definitely will be given opportunity of being heard. Now, let's start with the third chapter on this, chapter number 18, that is Environmental Protection Act 1986. We have already learned with air pollution and water pollution. Environmental Act is nothing but combination of both of them. Now you will ask me, ma'am, we already have a air pollution act, we already have a water pollution, then why we need environmental protection? See, we have various kinds of pollution as I have told you in the introductory video. Air pollution, water pollution, soil pollution, light pollution. So all this shall be included in your environmental protection. Whereas under air pollution, only air is there. In water, only water. Hence this Environmental Protection Act, it provides you an umbrella legislation where all kinds of pollution which is harmful to the environment shall be covered. Okay. So let's begin with this act. This act provides for protection and improvement of our environment. Environment is atmosphere where we live in. Okay, everything means environment. All living, non-living, everything comprises of environment. And we know that one type of component, environment has various components. One is dependent on another. like living is dependent on non-living, animals dependent on insects, insects dependent on some other species. So if there is something harm happening to one environmental component, it is going to harm the entire environment. Hence it's very much essential to protect our environment. So this act provides for long-term requirements of environmental safety. It also lays down speedy system to dispose the cases relating to the environment and also to certain situation which causes threat to the environment. As I told you, it is an umbrella legislation wherein all types of pollution shall be there under one roof. So who is a nodal officer under this? We have a central government. So central government shall be issuing various directions and orders under this act in order to protect and prevent the environmental pollution. So it gives orders for protection, improvement of quality of environment by setting up the standards for each and every industry and the activity. It also regulates the location of industry, which type of industry should be there in the highly populated area, which type of industry should be there in the thinly populated area. So it is regulated by your central government. It also issues various notification for health, welfare of plants, living and non-living. Okay, this is our Environmental Act. The penalty for non-compliance of any of the provisions of this act is very huge. It's very important to learn the penalty. So what is a penalty? The penalty for a violator, it is imprisonment up to 5 years or fine up to 1 lakh, or it can be both of them also. So either imprisonment or fine or both of them. This is for the first non-compliance. But when you have a continuing non-compliance, you are doing the non-compliance under Environmental Act continuously, then for continuation of that, additional fine of 5,000 rupees for every day till the day you stop doing the non-compliance. But still you are not stopping and this non-compliance is you are doing and it has gone above a year now. So beyond 1 year, if violator still goes on doing the compliances 1 year after the conviction of the first one, then you may be imprisonment for a period of 7 years. Understood? These are very strict. Please remember, first one is 5 years and 1 lakh. Second, 5,000 rupees every day, and third one, continuing non-compliance, that is continuing default beyond a year after first conviction, 7 years imprisonment may be there. Okay, so this is a penalty, please remember. Now starting with the act, first is our definition. What is an environment? Guys, we have read this in our third and fourth standard, right? Ma'am, we don't remember what we read yesterday. How are you asking us? No worries, we'll be reading over here. So envir includes everything. It is water, air, land, interrelationship between them. So interrelationship is there between water, air, land, human beings, other living creatures, plant, microorganisms and property. Everything is environment. What is environmental pollutant? It can be in any form, solid, liquid, gaseous, which is present in our atmosphere in such a concentration which is going to harm the living, non-living beings. What is the environmental pollution? Same, presence in environment, environmental pollutant. Do you find little similar? Now finding it easy? Great. What is handling? Handling means dealing with it in one or the other way. You are packing it, you are storing it, you are manufacturing it, you are producing it, you are destroying it, you are collecting it, you are using it. Any way you are dealing with it is called as an handling. What is hazardous substance? Very dangerous substance. It can be chemical, it can be any of the other substance. If you handle that and if you don't take sufficient care of that, your body will have an injury, and injury is sustainable injury. So that is a hazardous substance. So what is hazardous? Let's go to the definition. Substance or preparation by reason of its chemical, physiochemical property or handling is liable to cause harm to human beings, creature, plant, organism, property or the environment. Okay. Now, going to the act, I told you who is nodal officer? Central government. Okay, the central government gives you various rules and regulation in order to control the environmental pollution. So what are the rules given by the central government? And how central government shall give the rules? By publishing in the official gazette. So first, it lays down the standard for quality of air, water, soil, for areas and other purposes. So that quality is to be maintained. If you don't maintain, it's a infringement. If you don't maintain, it's a breach of condition. Then it also lays down maximum allowable limit of a concentration of environmental pollutant. That can be water, that can be air, that can be soil. It also includes the noise. Please remember, in different areas. It also provides for various procedure and safeguard when any industry is handling the hazardous substances. It also gives prohibition and restriction what industries have to follow when they are handling the hazardous substances. It also lays down prohibition and restrictions that one particular industry cannot be located in the thickly populated area or any industry which can be located in the thinly populated area. Also, when they are locating their industry in the thickly populated area, they have to follow the environmental rules very strictly. Then procedure and safeguards for preventing the accidents to happen in the industry, because most of the accidents happen in the industry when during the production process. So they provide for the procedure, safeguard to prevent that accident, and if accident happens, then what is the remedy available. So all these rules are given by the central government. Also, when any of the area is declared as air pollution, water pollution area, nobody in that area shall be allowed to operate any industry operation, and they will not be allowed to discharge any of the effluents or emit any of the air pollutants into environment exceeding the limit. So whatever standards are laid down, every industry has to follow that. Okay, central board or state board can more stringent on the industries. Now, there is something called as an environmental laboratory. I have already told you what is environmental laboratory, right? So, central government in consultation with the state board or central board may set up one or more environmental laboratories in a country. There may be number of environmental laboratories in the state, but for country specific there may be one or two. Okay, so it may establish one or more environmental laboratories. So if there are existing environmental laboratory which are private, government may recognize them and make them as a state recognized or country central recognized environmental laboratory. Over here we take the samples of air, water, any other pollutant and check about it. That is an environmental laboratory. So once environmental laboratory is established, it will also give what are the functions of the environmental laboratory. It shall also lay down the procedure, how to collect the samples, how to take the samples, how to examine the samples, etc. Okay, procedure for submission of laboratory for samples of air, water, soil, other substance for analysis. It shall also lay down what will be the fees charged. Okay, along with that it shall also carry out other steps which will expedite the testing in the environmental laboratories. So it shall give functions of the environmental laboratories. Now, in chapter number 13, we have read about the environmental clearances, right? So, whenever environmental clearance is asked for, what are the steps to be taken we are going to see now. Whenever there is any environmental clearance application by any of the industry, always there is a public hearing. But the first step industry has to take is apply to the state board for the environmental clearance. So for environmental clearance, application has been given to the state board. Once application has been received by the state board, it will announce the public hearing to be done, because if any of the person who is residing in that area, if they have any of the objection, they can put forward their objection. So for public hearing, your state board will be giving advertisement in the 2 newspapers. Okay, so unlike our company law, it is not in Hindi or vernacular. It will be randomly any of the 2 famous newspapers circulating in that particular state. After that, state board shall arrange for a public hearing by establishing a panel impact assessment. So there is a panel which will be called as a impact assessment panel, which will tell you what will happen if this particular industry is located over here. Then recommendation shall be received by impact assessment agency. On the basis of the assessment received, on the basis of the recommendation received and the public hearing, your state government shall decide whether environmental clearance has to be given or it is not to be given. Now, as far as penalties are concerned, we have already discussed with the penalty. The first penalty for contravention of environmental law will be imprisonment of 5 years or fine 1 lakh rupees or both of them. For the continuing default, per day 5,000 rupees till the day you stop your default. If this default continues even after 1 year of your conviction, then you may be sentenced to 7 years of imprisonment also. Okay, I hope you have understood the Environmental Act. So this is all for environmental protection. Now we are going to start with our next chapter, that is Public Liability Insurance Act 1991. Now you'll be wondering, what is this public liability insurance? Little different concept. You might not have heard about it. Now listen to this very carefully. When in a particular area there is an industry which is set up, in particular area there is an industry, the workers who are working in the industry, okay, for them we have seen that various insurance are taken. Okay, for the workers various insurance are taken and it is responsibility of an employer to take insurance for them. But in this particular area where the industry is established, okay, many residences are also there. So in the area where industry is there, the public is also living. Suppose any of the dangerous gas come out of this or it is leaked, don't you think it is going to affect the public who are located in that area? The answer is yes. So any of the public are victim, okay, they are affected because of some accident which is occurred in the industry. So who is going to cover their claims? We don't have any insurance for them. So don't you think huge burden of liability will be there on the employer of industry? The answer is yes. Okay, so in order to control his liability and in order to protect the public at large, it will be compulsory for every employer who is handling the hazardous substance, he needs to take insurance for the public at large. Okay, so that if something happens, some accident happen in this industry and because of that there is injury to any person or their property, that person can claim from the insurance. I would like to show you something. I hope everybody knows about this. I know you all have not born before this. In 1984, a dangerous accident or incident happened. This shook the entire country, not the country but the whole world, because such kind of dangerous incident has never occurred in the world. This is none other than your Bhopal gas tragedy. In the midnight of December 3, a dangerous gas or chemical leaked. Because of that, thousands of children and the people who were living in that vicinity, they got affected, some were died, some got some injurious diseases. They could see the effect of that even after the 10 years. Understood? So such things if happens, these all are the accidents. So it is not in control of an employer. Nobody will do such instances. Nobody would, like to take anybody's life. But these are the accidents. So when any employer is handling the hazardous substance, before handling that, it will be his responsibility to take the public insurance. I hope you understood this. What is the chapter about? The name of the chapter is Public Liability Insurance, and this has come out after the incident. See that 1984. So 1984 opened the eyes of the government of India. It's essential to have something for the public who are living in the industry's vicinity. So let's start with the chapter. Yes. So what is this act about? This act is for providing compensation for the damages to the victims. So whoever are the victims because of the accident happened in the industry, they may be victim themselves or their relatives or their property. Because of any hazardous substance in that factory, they will get the compensation. Okay. So it is for providing compensation for damages to the victims of accidents of handling any hazardous substance, or to save the owner of production or storage of hazardous substance from hefty penalties. So one point I also told you that, don't you think employer would be burdened? Yes. If he is not taking insurance, then he would have to pay all the liabilities himself. So to save him, it is always better he takes an insurance. So it provides for the compulsory insurance for the third party liability. Why third party? Because it's a public at large. Public is not working in the industry. Just because they are living in that vicinity where hazardous substances are handled. So for protecting them from any of the incident, it is always better to take an insurance, and this is compulsory insurance which every employer should take. So to sum up, when any employer is handling any of the hazardous substance, before handling he has to take out one or more insurance for the third party liability. Is it clear? Great. Okay. Now the owner shall buy one or more insurance policy before he starts handling of any hazardous substance. Okay. So when any accident happens, in knowledge of the collector, the nodal officer for this is collector of that area, he should immediately verify, is that accident really happened and what is the relief giving. Okay. So all this he should make sure. Now, what are the important definitions under this? What is an accident? Accident is very, very sudden. Nobody predicts that. So, it is fortuitous, sudden or unintentional occurrence, and while handling the hazardous substance, which results in continuous, intermittent or repeated exposure to death, injury to any person or property, but it does not include two things. Remember, war. Any damage done because of war is not covered under this, or any of the radioactivity or nuclear activity is also not covered under this. Hope understood. So what is handling? Handling definition we have already seen in the water pollution, dealing with that substance in one or the other way, using it, preventing it, manufacturing, production, storage, collecting, anything you're dealing with the hazardous substance, that is handling. Hazardous substance definition also we have seen in the Environmental Protection Act. It is a same definition. So who is the owner? Owner means any person who owns that industry or any person who is controlling the handling of the hazardous substance. It also includes, in case of partnership firm, any of the partners; in case of association of members, any of the members; in case of a company, any of director, manager, company secretary or other officer who is responsible for handling of that hazardous substance. Okay. Now we are going to the provisions of this act. So whenever any person starts handling of the hazardous substance, before that he has to take the insurance. This is very clear. So now, liability to give relief in certain cases on principle of no fault. See guys, you might have studied there is a principle of vicarious liability. If there is your fault, then only you will have to pay. But over here this principle does not apply, because over here we have a principle called as an absolute liability. What is the meaning of absolute liability? Your default is there or not there, your mistake is there or not there, does not matter. That leakage is from your industry, even though it is how much ever precautions you have taken, but incident has happened, so you are only responsible. Understood? So ultimate liability will be there of an owner. So when there is a death or injury of any person who is not a workman, remember, because for workman already we have ESIC, okay, or damage to the property which is from an accident, owner is liable for that. Okay, so owner mistake is there, mistake is not there, we are not supposed to know that. Okay, now, so it will be duty of owner, before he starts handling of any of the hazardous substance, he needs to take one or more insurance policy. Okay, so they will be providing insurance policy for the third party liability. So every person or every owner should get insurance policy renewed once it is expired. So till the time that person handles a hazardous substance, till that time the insurance policy should go on. Okay, yes. Now owner can get one or more insurance policies from any of the insurance company. Okay, now what should be the amount of the policy? Amount of policy cannot be less than the paid up share capital of the company. So it should be minimum of paid up share capital of company or 50 crore rupees, whichever is less. So paid up capital or 50 crore, whichever is less. Please remember this. Now, in certain cases, central government may exempt certain people from keeping this insurances. So central government may exempt CG, SG or any of the corporation which is owned by the central government or the state government or any of the local authority, where they have special fund for the public in such kind of emergencies. Okay. Now, whenever collector receives any information of such accidents, he will verify that and he will make sure whatever relief is claimed by the people, it is granted to them. Now, who can claim application under this? Okay, who can file application or who can claim the relief? First, relief can be filed in case of death of any person, in case of injury to any individual or any of the property. Okay, remember this. And who can file an appeal or who can file application under this? Injured person can file, owner of the damaged property, family member, in case of a death the legal representative, and if these four people are not able to file themselves, then they can hire any of the agent or a professional for filing. Understood? So they can hire an agent for filing application under this act. Now whenever collector receives such intimation that the accident has happened, it will verify. Okay, once it is verified, it will give receipt to the owner saying that this accident has happened, what have you done for this? So if owner says that this is not my liability, then the hearing will be there, and after giving opportunity of being heard to the owner, collector shall give a award. Okay, award will be given to the victim. Now, there is something called as Environmental Relief Fund. Central government establishes this relief fund, which will be called as Environmental Relief Fund. This fund, where do we utilize it? The central government shall utilize it for paying under this liability act. So whenever the major accidents are there, like the Bhopal gas tragedy I have showed you, where major losses happen to the public or the property. So from this fund, the funds or the money can be utilized. This fund is administered by your central government only. Okay. Now we are on the last topic, that is National Green Tribunal. Very, very important from your exam point of view. National Green Tribunal is nothing but it's a quasi-judicial body just like your NCLT. So National Company Law Tribunal governs all your company law related matters, right? So NGT shall be dealing with all the environmental matters. The difference between these two is that NCLT covers all the matters relating to the company, but environmental tribunal, that is your National Green Tribunal, it does not cover all the environmental law. There are only specific environmental law which is covered under the NGT. For other related environmental laws, we still have to go to the High Court. Okay, so this is the difference between the two. So in NGT, any layman would be really confused if this particular question is there. Where do I go? Can I go to NGT or the High Court? This is the only drawback of NGT. Apart from that, NGT is a wonderful institution which has been established by our central government. So without wasting any time, let's start with NGT 2010. As the act says, it's 2010, very recent act it is, and this has been established on one of the conference which happened in Rio in 1992. When there is a conference, our India is also one of the member in that. So we have to make changes in our existing law. So in Rio conference, they emphasized on two particular principles called as polluter pays the principle and sustainable development. So in their international environmental principles, the first one was polluter pays a principle. What is polluter pays a principle? Whoever is polluting the environment, he will have to pay the penalty for that. That is polluter pays the principle. And second is sustainable development. What is sustainable development? We can use all the available resources, but we should use it efficiently so that we can save for the future generations. It is not like that we are the last generation. We have various future generation, for them also we have to reserve it. So unnecessary wastage we should not do it. This is a sustainable development. Development is not bad, but wasting for the development is very, very bad. So on these two principles, the Rio conference emphasized. Because of this, we had an act called as National Environment Act 1995. This was replaced by NGT in 2010, that is National Green Tribunal Act 2010. So earlier we had National Environmental Act, also we had an appellate body. Both of them are replaced by National Green Tribunal Act 2010. So let's start. Yes, I'll be writing certain notes for you because this is very important from your exam point of view. Okay, so we are going to write the notes. Okay, so what is an NGT? NGT is a quasi-judicial body. What is NGT? It's a quasi-judicial body. Why do I call it as a quasi-judicial? Because it is not the legislative or the executive or the judiciary body, but it is established just to reduce the burden on the courts. That's why it's a quasi-judicial body. This you will be learning in your jurisprudence, okay, under the administrative laws. So this is a quasi-judicial body which entertains certain issues relating to environmental laws. Okay, relating to environmental laws. Now, when it's a quasi-judicial body, whenever there is any environmental dispute, whenever there is any environmental dispute, for all environmental dispute can we go to NGT? No, only few acts. So we will see which act, but whenever there is any environmental dispute, we can go to NGT. So when we go to the NGT, how does NGT solve that? Does NGT have to follow all procedure of civil procedure, criminal procedure? No. NGT do not have to follow civil procedure code. Okay, they don't have to follow civil procedure code, but when they are entertaining the dispute, they have all the powers of civil procedure code. So they have all the powers of civil procedure code, but they need not follow all of them. But very important thing they need to follow is principle of natural justice. What they need to follow? Principles of natural justice. This is must. If they don't follow principle of natural justice, then there is a problem. But if they don't follow the code of CPC, that is okay. Remember, this environmental dispute which we are talking about will only be a civil suit. Criminal suits cannot be filed in the NGT. I hope this is very, very clear. Great. Now, after that, state the objectives of NGT. We are going to read it point wise. State the objectives of NGT. Why NGT is established, we are going to learn. Let's learn in the question answer format. It becomes very easy. The very first objective is for effective and speedy disposal of cases. Effective and speedy disposal of cases relating to the environmental laws. Relating to the environmental laws. I told you there is one disadvantage of NGT. Okay, what is a disadvantage of NGT? The disadvantage of NGT is it is very, very limited. What is the disadvantage? Jurisdiction of NGT is very limited. So our layman who does not know NGT Act, he will be confused. For environmental query, I have to go to the High Court or to the NGT. Okay, so it will be very, very confused. Now the second objective, first objective everybody understood. Second objective is that it's an enforcement of legal action. It can take legal action, so it's enforcement of a legal action. Along with that, it also provides relief. It provides relief, also provides compensation in case of injury to person or property. So when there is any injury to person or property, we can go to the NGT. I hope this was very clear. Now coming to the next one. State the composition of NGT. State composition of NGT. So what we are going to learn, what is the composition of NGT? It's a very short answer. There is only one person, another person shall be for helping. He is a chairman. Chairman is a retired judge of a Supreme Court. Who shall be the chairman? Retired judge of Supreme Court. Only he can be chairman of your NGT. Okay. After that, now powers of NGT. State the powers of NGT. What are the powers available to the NGT? First, whenever they are handling any of the environmental issues, I told you they have powers of a Code of Civil Procedure 1908. Okay. So what is the power? While handling, you can write along with me, no problem. While handling of the disputes, it has power under, I am writing shortcut, CPC 1908. It's Civil Procedure Code 1908. Okay. And second one, Indian Evidence Act. Indian Evidence Act. So it has power under both of this act. But it's not compulsory. It's not compulsory to follow CPC or Indian Evidence Act. It's not compulsory to follow them. Okay. But what is important? They need to always follow principles of natural justice. Okay. This we have already studied earlier. Okay. Now we are going to see offices of NGT. Where are the offices of NGT located? Okay, the head office of NGT is at New Delhi. So as far as headquarters are concerned, or the head office, it is there at the New Delhi. It is also operating in 4 other states. So other quarters, it has one in Bhopal, Pune, Chennai and Kolkata. Please remember this, very important. Okay. Bhopal, Pune, Chennai and Kolkata. After that, next one, as far as jurisdiction of NGT, very important. I told you, no, only few environmental laws are there. Okay, so we are going to learn the jurisdiction of your National Green Tribunal. Which all laws are covered under this? The first one, we have to write the full name, okay? The Water Prevention and Control Pollution Act 1974. Second one, again the water. This is the Cess Act, okay? Prevention and Control of Pollution Act 1977. Sorry, my mistake. It's a Cess Act 1977. Third one, we have Air Pollution Act. So the Air Prevention and Control of Pollution Act 1981. After that, next one we have is Environmental Protection Act 1986. I hope you're writing with me. After that, we have Forest Conservation Act 1980. After that, sixth one, Public Liability Insurance Act 1991. And the last one we have Biological Diversity Act 2003. 2. So these are the 7 acts which comes under your NGT. Please remember this: Water Pollution Prevention Act, Water Pollution Cess Act, Air Prevention Pollution Act, Forest Conservation, Environmental Protection, Biological Diversity and Public Liability Insurance. Okay, this all are covered under NGT. Other laws are not covered. Kindly remember this. After that, we will see what are the benefits of NGT. Okay, as compared to the court, why we should go to the NGT? Is it compulsory to go to NGT instead of court of law? Yes. Can we go to the court of law for the company law matters now? No. On the same way, it will be compulsory to go to the NGT. Now, what are the benefits? First benefit is that they dispose the cases within time. So, first benefit, timely disposal of cases. First benefit is timely disposal of cases. Okay, this cases has to be disposed of within 6 months. Please remember, within 6 months from application they have to dispose the cases. So it's a time bound process. Secondly, they have given wider jurisdiction, hence they can give certain limit of punishment. So how much punishment they can give? Fine they can charge from 1 crore to 25 crore. How much fine they can give? 1 CR to 25 CR. And they can also order for imprisonment. They can order for imprisonment up to 3 years. Okay, so fine 1 CR to 25 CR, imprisonment up to 3 years with both of them or before that. Clear with this? Great. Now, next question. Now, who can file a suit in NGT? Who can apply in NGT? Who can apply in NGT? Any person whose injury is there to person, property, or in case of a death. So in case of a death, the legal representative, right? In case of injury, injured person, and in case of damage to the property, okay, when there is any damage to the property, then the owner of that property. Clear with this? Understood? Great. After that, next question. What is the time limit of filing the suit? Can you go any point of time after 10 years of accident? No. Always there is a time limit. So what is a time limit for making application for NGT? What is the time limit? The time limit is 5 years. Okay, please remember, 5 years from arisal of accident or arisal of cause of action. Okay, 5 years limit is given. So within 5 years of accident you can apply. Whenever injury is imposed, that is cause of action, within 5 years of that you should apply to NGT. Can extension be taken from NGT? Yes, but you have to explain reason for NGT. So can extension be taken? Yes. If you are not able to apply within 5 years, you have to file the extension application with the NGT, and NGT will be a sole authority to decide whether extension to be given or not to be given. So If NGT is satisfied by your reason, it shall give you additional extension of 60 days after 5 years, but not beyond that. So how much extension you will get? Only 60 days after 5 years, not beyond that. So what is the time limit? 5 years. And if you fail, then you have to file extension, and that too only 60 days after 5 years. That's it. Okay. After that, next one. When we want to file a suit in NGT, is advocate compulsorily to be hired? The answer is no. Any aggrieved person or any injured person, if he knows how to present the case, he can do it himself. Okay. So, is advocate required to be appointed to file a case? Do we need to appoint advocate to file a case? The answer is no. Person himself can argue, but what is the requirement? But person should be wearing formals. Okay, he should be wearing formals. That is requirement. Apart from that, nothing. He can file case himself. Okay. Next. Now, which languages are there in NGT? Can you argue in Hindi, Marathi? Language used in NGT. Only and only English, not any other language. Only and only English language is allowed. So if you don't know English, definitely you have to hire a advocate for that. Okay. Apart from that, if you are not happy with the order of the NGT, can you appeal? Answer is yes. Okay. Appeal against the order of NGT. We can file appeal to the Supreme Court. Okay. So any of the aggrieved party means who is not happy with the decision of the NGT. So any of the aggrieved party may file appeal with the Supreme Court of India, the highest court of land. What is the time limit? Within 90 days of receipt of NGT order. 90 days of receipt of NGT order. I hope this is very clear. Okay, so this were the important provisions as far as your NGT is concerned. For NGT, you can strictly refer to these notes. It is more than enough. Okay, don't do PhD in that. From exam point of view, only this much is important. Okay, so I hope you have noted down all my notes. One more time I'll show you. You can take the screenshots of that and later on you can write it. No problem at all. I'll just minimize it for you. Okay, so I hope you have noted down, taken the screenshots. Only do this much, that is okay. I have covered entire module. Okay, so don't worry on that. Thank you so much all of you. We are done with our chapter number 18 now. I hope you found it very easy and the weightage is 5 marks. So spend that much time on this. No need to spend more time on chapter number 18. Better to focus on chapter 13 and 17. Now let's discuss the past paper questions. Satvik is running a dyeing factory, seeks your guidance in knowing various responsibilities imposed upon his business to be complied under Water Prevention Control of Pollution Act 1974. So whatever responsibilities are there under water pollution, we have to write that. So what are those? Consent to establish, obtain consent to operate, then apply for the renewal of the same before expiry. Consent will be deemed to be automatically and unconditionally given if your application is not disposed of within 4 months. Then we may refuse of consent by giving reasons in writing. We have to pay the water cess. We have to affix the water meters. We have to provide the state pollution control board whatever data they required. We have to pay interest in case if we delay in paying water cess. We have to pay penalty if we don't pay the water cess, and we may get the rebate on that. Understood? These are the responsibilities of under Water Prevention Act. Next, whether NGT has power to hear civil matters related to environmental laws. If yes, under which enactments? Also explain whether provision of CPC applies to proceeding. This is very simple again. Can it hear the civil matters? The answer is yes on the environmental subjects. So we have to write those 7 acts name: Water Prevention, Cess Act, Air Pollution, Forest, then Biological, all this we have to write. Also, whether CPC is compulsorily applying? No. It applies, it has powers, but it is not compulsory to comply them, but it has to comply with the principles of natural justice, correct? Yes. After that, Liability Insurance Act is to save owner of establishment producing hazardous substance from hefty penalties. This I had explained you when we did this chapter. If any owner do not take the insurance, what will happen? He has to pay huge liabilities in case there is any accident and the victims have suffered the losses. So if this liability, if he shifts to the insurance company, he would be saved. Okay, so that's it with chapter number 18. So this is all for our part B.